Hello, everyone. Welcome to the AI Policy Conference organized by ET at Zurich and RegHorizon. And welcome to the session on AI and the rule of law, which is co-organized with UNESCO. I am Prateek Sibal. I'm a program specialist at UNESCO's Communication and Information sector, where I work on AI and digital transformation. I would like to welcome you all to this exciting panel where we have speakers who are sitting judges, professors, and lawyers and researchers from around the world sharing their perspectives on the intersection between AI and legal principles. But before that, I would like to invite Mr. Cedric Wachholz, who is the Chief of Section for Digital Innovation and Transformation at UNESCO, to share his opening remarks and about what UNESCO actually does and why is UNESCO here. Over to you, Cedric.
Thank you, Prateek, for these kind words of introduction. Warm welcome to you all, your excellencies, ladies and gentlemen, dear colleagues and friends. Let me start by my intervention by quoting Alan Turing, considered by many as a father of artificial intelligence. He said, "We can only see a short distance ahead, but we can see plenty that there needs to be done." We need indeed to address AI and justice challenges, and many of us also want to harness related opportunities. My name is Cedric Wachholz. I am heading UNESCO's Digital Innovation and Transformation section in the Communication and Information sector, and I wish to thank the ETH Zurich and RegHorizon for this opportunity to contribute to the AI Policy Summit. AI and the rule of law is an area of increasing importance in our digital transformation work. Yes, upholding the rule of law and harnessing artificial intelligence for the judiciary is possible, but how can we seize the many new opportunities AI offers? Today, judicial systems around the world are increasingly using artificial intelligence to analyze large volume of legal data, identify judicial precedents, help administrators streamline court processes, and to assist judges with forecasts on topics such as sentence lengths and recidivism rates. These are just a few examples of how AI can impact the day-to-day work of judicial operators. But these examples lead also to important questions and challenges we have to raise in this context. How can we overcome AI bias to uphold the rule of law? How can AI risks towards the right to privacy be mitigated? How can AI potentially affect the right to equality? And how can judges support a human rights-based and ethical adoption of trustworthy AI? In UNESCO, we are committed to supporting judiciaries in defending human rights and the rule of law. Within the framework of UNESCO's Judges Initiative, UNESCO launched in March of 2022, together with the Future Society, the National Judicial College, CETIC.br, NIC.br, and IEEE, the world's first global MOOC, a massive open online course on AI and the rule of law. The course is part of UNESCO's Global Judges Initiative, which has trained over 24,000 judicial operators in some 150 countries on issues of freedom of expression, access to information, and safety of journalists, and now also on artificial intelligence. This legal training responds to needs expressed in a survey of judicial operators worldwide, to which more than 1,000 judicial operators responded. They spelled out what they wish to learn about the use of AI in judicial systems. And the course therefore addresses two main issues. First, something many of us dream of: how can judiciaries harness AI in their administrative work to strengthen access to justice and enhance administrative processes? And secondly, how can judiciaries address issues of bias and discrimination in the use of AI, and of course, the legal challenges these AI tools pose? Over 4,500 judicial operators from 140 countries have already engaged with our online MOOC on AI and the rule of law. In this context, UNESCO is developing a global toolkit for judicial operators on AI and the rule of law, and the toolkit will offer guidance on the principles, on regulations and suggestions that underpin the responsible use of AI in judicial contexts. We trust this will be helpful, and we will assist judicial operators to reduce potential risks and assist enhancing judicial systems. I'm sure you're keen to learn more about this MOOC now, and before passing back to our moderator Pratik, I kindly ask colleagues to play our MOOC teaser video, and I thank you already now for your attention and warmly invite you to participate in this course. Thank you.
Thank you, Cedric. I would request the colleagues to play the video of the course from video that we have. I see there are already some questions on that.
So in a minute, sorry, Pratik, can we?
Yes.
For the video, sorry, please. Okay, Pratik, sorry, we have some issues with that video. Really sorry. We can play it like in 10 minutes or maybe.
No worries, no worries. No worries at all. In that case, then thank you, Cedric, for your remarks. And we would now be ready for an exciting panel. And first, I would like to introduce our moderator for the panel, who is Judge Isabella Ferrari, who is a federal judge, Second Regional Federal Court of Brazil, who has been a speaker in the MOOC as well, and a strong partner and supporter of UNESCO's work. Judge Ferrari, the floor is open for you to introduce the panel and take us forward in the discussion. Thank you.
Thank you so much, Pratik. I'd like to start saying that it's a pleasure to be here. It has been a pleasure to participate on this MOOC. And on our classes there, we were thinking about how AI would impact the legal field, and especially the judiciary. So the first thing that we need to understand to be able to discuss everything that we want to discuss today is the way that AI operates. So how does AI take decisions, and what are the advantages that arise from this resource, and what are the risks that we have? When we use AI to decide, we have the possibility of, instead of defining all the paths that will be taken in that decision, instead of doing that, stating everything that must be done, you give the system a lot of information, much more than we humans would be able to process. And the algorithmic system will find correlations in several layers among all of that information. And at the same time that it allows us to take decisions using an amount of data that we wouldn't be able to manage as humans. At the same time that using this resource allow us to take decisions that do not need to concentrate on each little step of this decisional path. At the same time that we do that, we must understand that AI decision-making is probabilistic. So we're talking about probabilities. We can say that an AI system has, for example, 97% of accuracy, 98% of accuracy, what seems to be wonderful for decision-making, but how can we use this kind of resource in the legal field where we're so used to gather ourselves in the concepts of what is good and what is bad, what is right and what is wrong. And once that we're delivering some decisions to algorithms that work processing a lot of data in multiple layers through a probabilistic approach, we also need to understand that once this is done, there is something in that decisional process that we lose. And this is called opacity. The decisional process that adopts algorithms at some scale is not fully transparent. And this is what allow us to miss some points of this decisional process. And at some situations, there might be errors in this process. There might be bias in this process, and we might have other kind of problems. So if algorithms takes decisions based on the data they're fed with, if algorithms takes decisions based on the way they are programmed, how can we expect that their decisions are fully scientific as they might seem at first sight if we live in a society that is biased? And that being biased, we can expect that this society produced biased data. We can expect that even if the programmers add very little information in AI systems, this information might also be biased by their implicit views. So we're talking about all of that in our panel, Legal Values and AI, Tensions Around Fairness, Accountability, and Transparency. And to investigate these issues related to fairness, accountability, transparency in AI systems, and how these situations interact with legal values like equal treatment under the law, we're receiving some great specialists. We're receiving Judge Fulgram, we're receiving Professor Ash, we're receiving Judge Khaled Ahmed, and we're receiving Dr. Angeline Waireji. So now I'll start with a question to Judge Fulgram, who is a district judge for the United States District Court for the District of Maryland, and also a professor of the University of Maryland School of Law. Judge Graham, I would kindly ask you, what should those who are listening to us know about AI? So which are the concepts and which are the basic dynamics of AI decision-making that you would highlight to a non-expert?
Good morning. Thank you very much, Judge Ferrari, and welcome to all of my co-panelists and all of you who are listening in. I think that what I would highlight for the key characteristics of artificial intelligence, AI, concepts and dynamics for people who are not familiar with it are sort of the following. First of all, I would highlight that artificial intelligence programs are pervasive in their current use, and that use is growing. We see artificial intelligence being used right now by decision makers and practitioners in healthcare, whether it's diagnostics using artificial intelligence technology that is supposed to be better than a human radiologist's ability to be able to read X-rays or MRIs, whether it's in robotically assisted artificial intelligence surgical tools. We see it being used in education in terms of analyzing educational data regarding test scores and tracking students through educational programs. Highly being used in employment, in the selection of qualified candidates from large pools of applicants. In transportation, where artificial intelligence is powering self-powered vehicles, not simply automobiles, but also aircraft and seacraft. It's being used in finance right now for predicting outcomes of investment strategies. It's being used to determine who is qualified to receive credit or a loan, either as a consumer or as a business. Extensively, it's being used in law enforcement in investigative techniques. It's being used, for example, for predictive policing to look at crime data to determine when a certain area is most susceptible to criminal activity so that police can be deployed when it's highest, when the highest need is there. It's being used throughout governments for example, for qualification of benefits for unemployment benefits or other government benefits. And it's being used in judicial systems in two ways, as our speakers have already said, and as Justice Ferrari mentioned. Number one, it's being used to help the administration of justice for court systems to use it to more effectively manage enormous amounts of legal information. It's being used, for example, in civil litigation to analyze gigabytes, terabytes, and exabytes of data in cases and try to analyze that in a way that will assist its use in the resolution of cases. And in some instances is being used as an aid to judicial decision-making. For example, some of the artificial intelligence software that makes predictions regarding recidivism and likelihood of committing future crimes. So the use is very pervasive. All right, so if we're using AI in all of these areas and the use is growing, what is the essence of AI that those who have not been immersed in this need to get a concept? Well, first of all, when we mention AI, there are really 2 or 3 concepts that come together. One is that AI is essentially the product of very sophisticated software programs run by algorithms. And an algorithm is nothing more than a formula, a step-by-step formula for how you accomplish a particular task. Now, algorithms can be written by individuals, humans, they can be written by machines, and they can be written by machines trained by humans or by other machines. Secondly, when we talk about AI, in addition to concepts of algorithms, algorithmic software, we're talking usually about machine learning, whereby either with the assistance of human training or by programming of the machine itself, or the machine simply looking for patterns and similarities or discrepancies, where the machine analyzes a large amount of data and makes certain decisions. And finally, it is frequently used in natural language programming. Think of your Siri or your Alexa or your other programs that are fairly sophisticated in interacting with humans. The key is that artificial intelligence is thought to be the use of algorithms in software programming to do functions that previously only humans could accomplish. And I think that when we talk about the use of artificial intelligence in judicial systems, as Justice Ferrari indicated, we're concerned about a number of things, whether or not it is the use of artificial intelligence in the administration of court systems to make them more efficient and to increase access, but also the use of artificial intelligence software applications as evidence that may be used to resolve civil or criminal cases brought to a judge or a jury to resolve. As Judge Ferrari said, we are concerned about bias in how the AI operates. Why is that? Because the artificial intelligence has to be programmed. It is programmed by individuals. We know that individuals may have explicit bias, but they also may have implicit bias that they're not even aware that they are bringing to the programming process. The data that is selected to train the artificial intelligence software application may itself be biased. If the population sample that you use to train the artificial intelligence is limited to one segment of the population, one race, one gender, one age, one characteristic, then what it learns is based upon that, and it has a much less accuracy rate when you try to apply it to population groups for which it has not been trained. Secondly, many of these artificial intelligence software programs are privately developed by organizations or institutions that intend to license it to be used by others. They invest a significant amount of time and resources to develop it. It becomes their confidential commercial information that they have an understandable right to want to protect. And what happens is that they make the decisions as to how it is trained and tested to determine 2 key concepts. Is it valid? Does it accurately do what it is trained to do? And secondly, is it reliable? Does it consistently perform accurately across sample populations that are based upon similar data inputs? And since these are private, often private organizations, since there are not national or international standards for what is trustworthy AI or transparent AI, they're being developed, but they're not uniformly applied now. We worry about these concepts. Has it been tested? And if so, how can we determine whether it is both valid and reliable? And finally, we worry about function creep, which is a concern that happens when you develop artificial intelligence software to perform a certain particular function for which it is well programmed and trained and adequately valid and reliable, but then it starts being used incrementally for other purposes for which it was not intended. A specific example being the use of recidivism prediction tools, not for their originally intended purpose of determining what supportive services needed to be given to someone released on bail while awaiting adjudication of their case, such as mental health or drug treatment, but rather being used to predict recidivism for purposes of determining the length of a sentence to be imposed. And one of the things that we worry about, to address what Judge Ferrari was saying, is the level of accuracy that you must demand in artificial intelligence is directly proportional to the risk of an unacceptable outcome if you get an error in terms of what the output is. And I think those would be the main concepts that I would offer up to someone not especially familiar with AI, as it is a dynamic concept that affects the administration of justice. Thank you.
Thank you so much, Judge Grimm. I think you have perfectly highlighted in some minutes. I mean, the view on how our societies are changing because of AI in multiple fields and how it is getting to the legal field and the main points of attention. And to follow on this discussion, we're now hearing Professor Elliot Ash. Professor Ash is an assistant professor of law, economics, and data science at ETA Zurich Center for Law and Economics. And to follow on this discussion, I'll ask Professor Ash, what are some of the potential implications of AI in the law and in the legal system?
Thank you, Isabella. I just wanted to note quickly that Justice Singh has joined us. So in case you want to go to his contribution first, that's all right.
I'll ask him just after yours, because he'll bring a specific view on India.
Thank you very much. So I have a few slides just to give a bit of more specific context to a lot of the really nice points that we just heard from Paul Grimm giving about a nice overview of the role that AI might play in the justice system. I want to point to some of my own research in the India judicial system, kind of zeroing in on issues of bias along gender and religion and caste, where, for example, only 4% of high court judges in India are Muslim. Only 20% of district court judges in India are female. And there's also issues of overrepresentation in the incarcerated population of Muslims. And this issue is that if judges have some in-group or out-group bias or some prejudices that have often been observed in other contexts, this could create some discrimination in the India criminal justice system, notwithstanding that our goal in justice system is for justice to be blind and to treat people based on the facts of the case rather than their characteristics. So this is part of research with other researchers at Dartmouth, Imperial, Johns Hopkins, and the World Bank on in-group bias in the Indian judiciary, evidence from 5 million criminal cases. Just a shout out to the Indian justice system in terms of the availability of data. With the Indian e-courts platform is this amazing resource that is going to be influential, not just in making justice decisions more efficient and consistent, but also really boosting social science and analytics of justice. And we were able to download 80 million case records just from a 9-year period from this platform for all of India. This data is all of the cases from the lower judiciary, the district and session courts. This is just amazing to work on India, where just the sense of scale is so different, where you have 7,000 courts, serving 1 billion people. We also have very detailed information on the officers in the justice system. We have information on 8,000 judges, where they work, when they work, and some information on their background and their names. And this gives some really nice visibility and transparency on the judicial system, which has value on its own right, but is also really useful for when you're doing empirical social science research. And just one kind of quick first item that AI tools or machine learning can help in supporting research and understanding the judicial system is that we actually don't have demographic data on these cases. So we don't know, if we want to know, is there some bias towards women or men, or is there bias towards Muslim individuals or individuals during castes? We actually wouldn't be able to determine that from the data set because it's not collected, which is good from a privacy standpoint, but it's an impediment to research. And so we actually built an AI-based, a neural network-based classifier that can be applied to the first and last names of the defendants or the lawyers or the plaintiffs, other actors in a case, and learn with 97% accuracy the gender or religion identity of the individual. And so this is something that we built open source software using open source data, and we put this classifier online. We then made anonymized data. So we took out the names, and we wouldn't want to, I think that would be a violation of privacy. All of this is public data, but we don't want to make it too easy to search through everybody's names. We anonymized it, added in the gender annotations, and made an open data set for everybody to use. This has since been used in a number of other research and some blog posts and things like this. I think the fact that India made the data available and we were able to use it for research purposes is really great. So we took this data, we looked for bias towards along gender or religion margins, and we actually didn't find much evidence of it. So this is actually quite encouraging, given like the anecdotal evidence that there is a lot of bias towards women and Muslims in Indian society. It seems like that bias isn't happening at the level of judges making decisions about whether to acquit defendants in criminal cases. We did find some evidence of different religion bias during Ramadan, and we found some evidence that judges might favor defendants from the same close cultural group or close caste as proxied by having the same last name. But overall, we have some optimistic evidence that in the Indian justice system, some equality and is guaranteed. So I think that the upshot of these is that data science tools and AI are going to have implications, not just for judge decision-making, but for scientists and policymakers interested in understanding the justice system and judge decision-making. It also opens up many other questions. So if there isn't bias among judges, where are the biases coming from? And for example, we're using in future work some of the natural language processing tools that Judge Grimm mentioned applied to the sentence orders that these judges are giving to understand, is it coming through the harshness of the sentences, for example. So I hope this is a starting point from the social science perspective that will lead to further discussion along with the other panelists. Thank you.
It is indeed a great starting point, and it reminds us of something that many people forget when we're talking about opacity and bias in AI decision-making. And the point is, of course, we need to discuss and we need to be worried about that. But when we have like human decision-making, at some point, our decisions, ours as judges, they also have some level of opacity. We here in Brazil, there is something that you say that you never know what goes on a judge's head. And of course, there's also like bias in the heart of judges at some level due to our position in society. So when we make this change in several fields of life, from human decision-making to hybrid decision-making, combining humans and machines, we might have the opportunity to think about these human problems of opacity and also bias. And we might have a chance to make the necessary corrections on that. So now we welcome Justice Jasmeet Said. Justice Said is a judge of the Delhi High Court of Law. And after welcoming him, I would ask him kindly to tell us how are Indian courts using AI to support judges, and if there are ways to help us to get to rulings quicker and in a more fairly way. Good morning or afternoon or good evening, Justice Said.
All right, thank you. Good afternoon to everyone, to all the panelists and the respectable judges. So at the outset, what I would like to say is that in my I was a lawyer before I became a judge, and I had a practice of about 30 years. And thereafter, I was elevated to the bench. So in my experience, as far as the judges are concerned, I have not come across instances of bias. I would just say that as far as the judges are concerned, I have bias towards women or Muslims or particular caste or particular, India is a land of religions and castes. But in my experience as a lawyer or as a judge, I have not come across instances of bias, so as to say. Judges may have views. They may have different, different ways of handling a particular issue. But bias would not be the word I would be using here. Having said that, on the issue of artificial intelligence, so India is embracing artificial intelligence in a big way. So our honorable minister has expressed the need to adopt the cutting technologies of both machine learning and artificial intelligence to implement the e-courts. What we have at the High Court level and at the Supreme Court level are now the e-courts. Delhi High Court, there is we are on an e-portal wherein there are no paper files anymore. Everything is e-filing, it is e-documented. The lawyers are on their are using e-technology. So that way, we are embracing the e-technology in a full and a meaningful way. Now, what has happened in the Supreme Court is that there are two programs which have been implemented. One is called the SUPACE. So it is a artificial intelligence powered workflow, which is divided into 4 parts. One is a file preview, one is a chat box, one is a logic gate, and one is a notebook. The files are available in PDF forms, which are converted into text. The text and then voice-enabled chat box helps to give an overview of the case. The extraction system gives information about the case and the chronology, the precedents, the judgments. And then what happens finally is an integrated word processor makes the end-to-end system, and it is used by the judges. Similarly, there's another software called SUVAS, which is Supreme Court Vidhik Anuvad software, which is again an artificial intelligence system, which helps the translation of court decisions into numerous regional dialects. So again, these are the systems which have already been implemented by the Supreme Court, which is the highest court of our country. Now, what I feel, which is what has been emphasized, is the bias of the artificial intelligence system. See, end of the day, artificial intelligence system is based upon the data that is fed into the intelligence system. Let me give you an example. When India gained independence in the 1947, there were a lot of migrants who had come to Delhi, and it was felt that there are people who are unable to own properties, and they would generally be on rent and on lease. So therefore, it was felt that these people needed some extra protection, and there was a legislation called Delhi Rent Control Act, which was a legislation of the 1950s. Protection was given to the tenants that they cannot be evicted until and unless there are 3 or 4 grounds. Then in the year, with the passage of time, it was felt that all the tenants have been settled in Delhi for about 40 to 50 years, and now they are no longer requiring that protection. So the judicial trend was from pro-tenant, it was shifting to pro-landlord. Now, if we take the entire gamut of rent control legislation, so about 70% of the cases would be pro-tenant, and 30% or maybe 25% would be pro-landlord. Now, if that is all fed, the result would still, even in today's time, when the entire conspectus has changed, would be in the nature of pro-tenant. So therefore, there is a bias because of the data that is fed into the system. It is only going to be analyzing the data that is fed. But having said that, again, according to me, artificial intelligence can go a long way, where we have something like one judge for about a million people, that the person, before he goes to court, before he knocks on the doors of the justice system, must know factually or reasonably that where he stands. If there's an artificial intelligence system that provides him that in such kind of cases, this is the success rate, this is the time you will involve yourself in litigation, the decision of the person who goes to court may be different. She may choose not to go. He may choose alternative dispute redressal, like a mediation process. You see, so that would go in a long way in reducing, according to me, in reducing the number of cases. If a person already knows that in a similar kind of a case, this was the outcome, this is the time it took, this is the cost it took for the person, the decision may be different. So that way, artificial intelligence, according to me, would go a long way. Artificial intelligence would also go a long way in kind of drafting contracts. Your lease agreements, so that, because that is not something that is something which does not require a human or a humane approach. There are contracts, you feed in the data and you can get pleadings, the lease documents, the contracts, that all can be done through artificial intelligence. But according to me, again, artificial intelligence is the new technology. We must welcome it. It is change for the better. It is change of the future. But to say that it can supplant judges, it cannot be. It can only supplement. It can give you the data. It can give you precedents. It can give you the issues, how it has been decided by other courts, what is the perspective, but only to supplement. It can never be to supplant. So that's my view. Thank you. Thank you very much.
Thank you, Justice Sait. And it's interesting to see when we talk about AI decision making, it's interesting to realize that we're talking about decisions that are based on data that has previously fed the machine. And when we're talking about decisions based on previous data, we're talking about decisions that are based at some level in the past, because this data is in the past. So as Justice Side said, it's important to state that we shouldn't expect, I think in any of the fields, that AI would completely substitute humans, take our positions, because every time when there is the possibility that a new decision must be taken because the situation is different or because a new problem has arisen, for these two situations, the state of development of AI that we have nowadays, that is like weak AI, it's not a grand intelligence, it's not strong AI, it's just weak AI that is trained to solve specific problems. For this situation, every time that you need a new decision, a creative decision, or every time that you look to a situation and think it's a different situation, it should have like a new answer or a creative answer, or this is different at some level from everything that we have seen before. For these situations, AI can't help us. It can help us in the huge amount of situations that are just repeating previous facts or previous situations, but for new solutions or for this act of distinguishing, human view will always be needed. And to go on with our discussion, we're now receiving Dr. Angeline Waireggi. Dr. Waireggi has a PhD. She's a senior research fellow at the Center for Intellectual Property and Information Technology Law. And she's also a co-director of the Center for Intellectual Property and Information Technology Law, Data Governance Policy Center. Welcome, Dr. Waireggi, and I would like to ask you if you could highlight some ethical concerns for us that should be evaluated upon the adoption of AI in legal systems.
Thank you so much, Judge Ferrari. Please let me know if my audio dips in and out. And I will be referring more specifically to Africa because most of our research in AI and also within the data sphere has an African perspective. And another caveat is I will say Africa, but I would like to really stress that it's not a homogeneous entity. It's just easier to say Africa in this case. That said, the continent dipped its toes into the AI pool a little bit later than elsewhere around the globe, specifically referring to AI activity in the EU, UK, and in the States. That's a little bit more developed than it is here. But we do have an emerging AI ecosystem. And by that, I mean, we do have AI activity in terms of end users. So people are adopting the tools and using them. And we do also have AI developers emerging from the continent. So if you were to take a look, you would see that we have a number of applications that have been developed and deployed in the continent within certain sectors. That does not really happen or is not currently happening within the legal system. So all of the tools, at least from our research so far, that have been deployed within the judiciary, let me not say all, most, that have been deployed within the judiciaries have been imported in. There are a number of AI tools that are being utilized in legal firms that have been developed in Nigeria, for example, has 2 AI systems that have been developed and are being used within Africa, within the legal firms. But within the judiciary, most of the tools that we're seeing have been imported in. And that's just the general trend that we see in Africa. Again, very general statement, but we tend to be more importers and consumers of these texts, and then we tend to export our data out. That leads to two large concerns I'd like to talk about. One has already been touched on, is the issue of bias. We know that AI platforms are human endeavors, and they're coded by human beings, and they are trained with data sets that are compiled by human beings. If all of this activity, if all of this foundational activity is being done elsewhere, and then we're simply importing those tools, they've not been specifically localized and contextualized to the problems within the African continent or within a specific nation in Africa. I mean, there's a little modification you can do, but then the question is, how much does that help, right? So issues of bias are, you would think, are almost inevitable in a case such as this. So we're using tools from elsewhere, and we're trying to sort of rig them to work within our specific context. I mean, there's something we could do maybe to mitigate those issues, but I would think right off the bat that that would be a primary concern, that there would be bias in there. The other one I'd like to touch on is issues of access. So access, I mean this in the broadest terms. There tends to be a large disparity in terms of financial resources, in terms of digital resources, in terms of digital knowledge and digital literacy. And this tends to be seen across the board. I can speak specifically for Kenya. We have a massive rural-urban divide, I think, across all sectors, across all values, across all aspects. So if you're looking at Nairobi, for example, which is where I'm based, access to internet, access to technological tools, things like cyber cafes, they're very prominent here, right? So if you transfer that gaze to some place that's a little bit more remote, let's say in the northern eastern parts of the country, then I don't think you see a lot of Wi-Fi towers right around the villages, and things like cyber cafes are a little bit more sparse. So we could deploy these AI tools in the judiciary with the intent that they would ease issues of access, but then the question arises, is that really feasible given our current environmental setup, given our current digital setup? Also, the disparity runs within the judiciary as well. Kenya has an ICT strategy to ease the case backlog in the Kenyan judiciary, and this was deployed and implemented in 2017. But before COVID, what we're seeing is a lot of these ICT functions, a lot of these ICT policies were only being enacted in the major cities. So Nairobi, Mombasa, Nakuru, like the really big cities, you would see judiciaries where they had been a concerted push to really, really invest in their ICT tech. But what happened during COVID is we all went on lockdown, and the disparities between the judiciaries in the urban counties and the rural counties were really, really stark. They really, really came to the forefront. And the government had to, within a very short timeline, really put in a lot of money, a lot of time to also deploy these tools in the rural areas so that citizens could still have access to judiciary services. So that's another thing what we need to consider when we talk about access. Is this equitable across the board? And then I will talk about literacy and knowledge as one lump, although they're not really. But in terms of digital literacy, really meaning at the very basic level, can people operate these tools? Do people know how to, from a mobile device or from a laptop, go onto the website and navigate that entire thing? That, again, there's a stark difference in digital literacy when you look at people in urban areas versus rural areas. And then digital knowledge is, I think, a step further than that. Yes, you can know how to navigate, but do you know the full impact of using these tools, right? We talk a lot about data justice within CIPIT's Policy Center. And a big part of that is knowledge. Do you know how your data is being used in terms of how whatever data you put out there may be used by these systems within the judiciary to adjudicate your case, even if there is like human help in that process? And also, do you know how your data is being stored and processed in terms of privacy issues? That can come and bite you back. So data knowledge, I think, is also very asymmetrical. The people who work in this field, the people who are a little bit higher on the social economic ladder tend to have a little bit more interaction with data and maybe a little bit more knowledge in terms of the impact of how these systems can and are being used and how it can impact them. So when we talk about ethical and responsible AI in the judiciary, I think that's really two of the biggest things that we're concerned with. Bias, because everyone needs to know that they're being adjudicated fairly, and then access. It's all well and good saying that these tools will help, but if it's only people within a certain status quo that are able to access them, then people in vulnerable groups don't benefit as much. So I think those would be the two biggest issues ethically that I think we need to discuss. Thank you.
Thank you so much, Dr. Wairegi. And now that we're really concerned about everything that she said, we're hearing Judge Khaled Ahmed. Judge Ahmed is a senior rule of law, United Nations qualified legal practitioner for the last 28 years, has been a public prosecutor for 5 years, and a judge for 23 years. And I'd like to welcome Judge Ahmed and ask him, that is a person that is highly experienced in the implementation of justice reform programs in the region of Middle Earth and North Africa. If he could tell us some of the benefits of that AI might bring to judicial systems.
Thank you, Judge Ferrari, and thank you for the organizers for this kind invite. I am happy to be here with you. Do you hear me well, since I'm talking from a UN compound in the middle of the desert, so our internet is not always stable. So do you read me? Okay, all right. So in order to answer this question, I should say that let me start by giving you an example of what's happening on the ground so that everyone would understand how beneficial is the artificial intelligence to the Arab judicial systems. Also, I would like to talk about the main obstacles that Arab judicial systems are facing. First, to start with, there is a severe backlog of cases in most of the Arab countries. So many reasons for that. One of them is the shortage of manpower in all judicial systems without an exception. Third, and most importantly, almost 17 out of the 23 Arab judicial systems are still using handwriting instead of electronic means. Therefore, when you talk about artificial intelligence in those systems, you're talking about black and white. You're talking about day and night. It is noteworthy to say that artificial intelligence was introduced to most, if not all, the Arab countries because of the COVID-19 pandemic. We now see most of those systems using Teams and Zoom to review detention orders instead of transferring detainees from prisons to the public prosecution. Here in Libya, we use the same techniques to conduct virtual court hearings because the court system was shut down on the 15th of March 2020 for 6 months. We had more than 7,000 people stuck in prisons, either on pretrial detention or did not even conduct the investigation yet by the public prosecution. So it was really important to assist the judicial system to overcome those difficulties by using some basic and simple elements of artificial intelligence. Another example of the use of artificial intelligence in the Arab judicial system is Dubai. Nowadays in Dubai, they are using the e-justice techniques in a very advanced manner. All court documents and investigations are electronic. When interviewing a witness or a victim that does not speak Arabic language, they use this system that provides spontaneous electronic translation. It's almost, according to the Ministry of Justice in Dubai, it provides 99% accurate translation from 6 different languages into Arabic. And it is printed in the hand of the prosecutor or the judge immediately. They're also using e-systems that provide analysis of the information contained in the database. We do not have such example in the other 22 Arab countries. Only Dubai that does that. At this time, most of the Arab judicial systems are considering gradual introduction of artificial intelligence into the judicial work. We see countries in the MENA region already started to implement using advanced technology to type the court records or the investigations or for the translation. We are using computers being used more oftenly. We are seeing a lot of advancement in the treatment of prisoners inside places of detention. These are all small, shy samples of the use of advanced artificial intelligence within the judicial system. The reason why I described it as shy is that most of the judges and prosecutors are skeptical about, is this artificial intelligence going to replace judges? So this is actually taking place at this time, delaying some of the progress in the way of using artificial intelligence in some of the Arab judicial systems. We're trying to deal with that through dedicated programs to increase the capacity, to increase the knowledge of judges and prosecutors and officials at the level of ministries of justice, to try to make them understand that one way or the other, you will end up using artificial intelligence, simply because artificial intelligence nowadays, when it is actually implemented in Dubai, you would see the difference in the backlog. You would see the advancement in the economic courts that they established only for the purpose of promptly giving rulings or decisions in such cases or complaints. And then when they introduced the artificial intelligence, they started to see a lot of indicators that are simply being described as incredible, because judges nowadays are using those techniques to analyze the database before them. For example, a judge sitting in Dubai ruling upon a conflict between a company that is based in Turkey and another one that is based in China for a transaction that was conducted on the soil of United Arab Emirates. They are able to extract information from the database very, very fast and use that data to decide what to do with the case. How can they promptly implement the ruling itself is another issue. They're using all possible means that provides to them up-to-date information that is facilitating to them issuing rulings, court decisions, and also assisting public prosecutors in the way they conduct their investigations. This is simply how artificial intelligence is important to judicial systems in the Arab region. And I'm happy to take any questions. Thank you, and over to you, Judge.
Thank you so much, Judge Ahmed. It's interesting that you mentioned backlog. And I think that the Brazilian situation, the country where I live, is one of the worst in the world when we look at the relation between backlog and population. We have nowadays 78 million lawsuits of backlog. I remember I've been in an event with Professor Richard Susskind around 2018. I think that, just to make a comparison, India by that time had something like 30 million lawsuits of backlog. And Brazil has had by that time around 90 million. Now we have a little less. So in these environments, when you have a lot of backlog, like looking at technology is a way to try to deal with this. And perhaps because of our special in the bad sense of it, perhaps because of our special situation, Brazil is one of the countries of the whole world that has more initiatives of AI in the judiciary. Nowadays, we have around 64 projects in our country, projects that are related to very different things, from dealing with the lawsuits, identifying repetitive lawsuits, to suggesting laws that should be applied to judges, up to drafting decisions. So it's really something, isn't it? And when we see this scenario, we start thinking about some of the legal values that might be tense by AI, by artificial intelligence. And to talk about this issue, about the legal values that might be tensed by AI, I would call again Judge Grimm to share some ideas with us.
Thank you, Judge Ferrari. And I have been listening with fascination to the comments of all of the speakers. And it is reassuring, I think, to hear that from whatever part of the world, judicial scholars and practitioners look at how we can better serve the public that we are required to serve, that we're all observing similar issues and challenges, and seeing the hopeful possibilities for the future, which I hope through programs like the one that we're doing now causes a great deal of cooperative exchange, such as already has been going on in this program and other programs sponsored by UNESCO and the other organizations that have put this program on. So we have a tension, a natural tension that develops between competing doctrines in a judicial system. So, for example, we have thoroughness of decision-making versus speed in rendering decisions. There's a well-known expression that justice delayed is justice denied. When I first became a judge nearly 26 years ago, I was told that the imperfect decision that I render today is better than the perfect decision that I never have time to get around completing. So we have various tensions that require some sort of a balance. I'll give you one specific example that comes up a great deal in artificial intelligence. You have a very strongly held principle in most judicial systems of due process, fair process. Fair process means that the litigants have access to sufficient information, that the procedures give them notice of what they must deal with in the case, that the mechanisms ensure fairness and a balance, and that it provides a decision as quickly as possibly can be done. In the federal system, the rules of civil procedure in the United States say that the rules of procedure are to be employed to secure the just, speedy, and inexpensive resolution of all cases. So we have due process. I need to know. I want to challenge this evidence against me. I need to know how the evidence operates. So let me have access to the information so that I can come up with a challenge, particularly if the information is based upon artificial intelligence software technology. I need to know how that works to be able to know whether it is valid and reliable, whether even if it is methodology that's valid and reliable, whether it's been reliably applied to the facts of this particular case. And if we look through the lens of due process, we would say, well, that's reasonable. We should encourage that. On the other hand, there's a competing interest of trade secret protections. All of our speakers understand implicitly that the development of artificial intelligence software technology is not always done with open source programming like Professor Ash was talking about, but oftentimes is developed commercially and by entities that want to capitalize and monetize their artificial intelligence technology. I'll give you a specific example. Within the United States, one of the techniques that is being extensively used in criminal cases, both to secure prosecution convictions when that is where the evidence leads, and also to show, to procure results of acquittals or to determine when someone has been unjustly convicted, focuses on DNA analysis. There are very sophisticated software programs that are being developed and used regarding probabilistic genotyping that use very sophisticated statistical algorithms to analyze the DNA alleles from individual or multiple donors on a particular item of evidence. And to then create a probabilistic estimate comparing the likelihood of some random member of a particular population having left that DNA as compared to the sample that was taken from a suspect. These programs have been used in about half of the states in the United States, in both federal and state courts. Whenever you have a criminal case, it is not unusual for the defendant to counsel to say, now, wait a minute, we need to have the software. We need to look at how this operates because this is all statistical analysis. It's very complicated. One program has 170,000 lines of computer code. We need that code. We need to look at that code. We need to be able to see whether there are errors in the coding that might affect the output, because if the jury hears that there is a 1 in quadrillion chance that someone in the population other than this particular defendant is the source of that data found on the evidence, then that's it for the jury. They're going to say, this is the person who was there and this is the person who was responsible. But what oftentimes happens is that the developer of the software, analytic software, has licensed that to all of these crime labs and these law enforcement organizations, says, if I give up this code that I have developed over 25 or 30 years and have tested, and I can demonstrate through validation studies that it works, then my competitors can take the benefit of 30 years of my own hard work and labor and use it against me. And we have seen cases in the United States in which some courts have come out in favor of prohibiting the disclosure of trade secret information dealing with how artificial intelligence systems operate for protection of that commercial property of the software developer. Other courts have said, no, we come out in favor of due process. You can't have it both ways. You can't use this evidence against someone, particularly when it may be highly prejudicial to them, without giving them an adequate opportunity to be able to challenge it. And so how do you strike that balance? And that's emerging. You have cases where, for example, you have some courts have experimented with using protective orders that give a certain amount of access to the software without disclosing the code so that it can be fairly tested. So we see these competing notions, due process versus trade secret protection. Secondly, the tension with legal values. I think that all of our speakers have sort of touched on this in one sense or the other, is that AI programs are so sophisticated that we're never 100% certain how they operate. There's an issue of transparency. In our legal culture, we have this notion of transparency. We need to be transparent. If a judge rules, a judge must explain the basis of their ruling so that the higher court can evaluate whether or not they ruled in error. We need to have transparency in our evidence. We need to have transparency in access to information. There is oftentimes a question for artificial intelligence software programs, just how transparent they can be. And you hear that in phrases such as, is it a black box? We don't know how it operates. We feed data in, we get output, but we don't know what happens when it gets in there because the data has been trained by a human, but then has analyzed the data that it looks like and then trains itself by making adjustments in how it operates to look for matters that perhaps the programmers can't even explain. So is there a way, I mean, does every box have to be crystal clear so that you can see how it operates? Or can you have, how do you have sufficient transparency to rely upon the output? What are other legal values that can be in tension when we talk about artificial intelligence? Well, obviously, the computer scientists and data scientists are familiar with the acronym GIGO, garbage in, garbage out. And as Justice Ferrari and other speakers, Judge Ferrari and Justice Singh and Judge Agman have said, we are trusting on the programming of this artificial intelligence to give us reliable results. But what do we mean when we talk about reliable results? We mean that the artificial intelligence has been programmed and tested sufficiently so that it is acceptably valid, meaning accurate, for a particular use, and that its validity has been demonstrated across a sufficient number of trials on like data so that we know that it is reliable. Validity means accuracy, and reliability means consistency of accuracy when applied to similar data. But we don't have any one level of minimum threshold of validity or reliability. Judge Ferrari talked about, 99% accuracy. And I think that other speakers have talked about a high percentage of accuracy. And you might say, well, geez, 99% accuracy is perfect. There's such a small error rate here that of course it's got to be good. But the answer is that there's no one threshold minimum accuracy level depending upon what you're going to use it for. I'll give you two examples. If you're using artificial intelligence software programs to determine how long a sentence to impose on someone who has been convicted of a crime, and you want to deter them from committing future crimes, and you want the sentence to be long enough but no longer than necessary to do that, if you have artificial intelligence powered predictors of whether they will recidivate against, and if the risk of getting it wrong is that someone gets a 20-year sentence instead of a 2-year sentence, then you need to have a higher confidence level that the programming is such that it doesn't have the type of bias or programmatic problems in it to produce an outcome that is not acceptable. So in that particular case, you might say, well, I don't know, 90% is not good enough. We don't want 1 in 10 cases producing an unfair sentence. Now look at it from a different concept. Let's jump from law for a moment and let's look at medicine. Let's say that we have a person who has been diagnosed with a terminal illness and told that they have fewer than 6 months left to live. They are also told that there is an experimental, not yet approved for public use, medication that has a 60% likelihood of completely curing them, but a 40% chance of killing them. Now, most cases, you would say that 60-40, there is a pretty significant likelihood that that person will die. They'll be in that 40%. It's almost 50-50. But there's a 60% likelihood that they may be cured. Is that an acceptable error rate? Well, from the perspective of a person who's been told that they only have 6 months to live, they may be willing to accept that 40% chance of passing earlier as an acceptable trade-off for a 60% chance of being cured. And so what that illustrates is that we have these tensions in terms of risk of error, which pushes us toward higher and higher and higher demands for validity and accurate and reliability demonstration. But at the same time, we need to realize that for certain types of decisions, you don't have to get it perfect. You just have to get it good enough. And there's an old expression that the perfect is the enemy for the good. So that can be an area of challenge. The final area of challenge that we want to realize is this. Judicial systems operate under rules. We're rules-based systems. We have rules of substantive law. We have rules of procedural law. We break things down into sequences. And whenever we have something which is scientific or technical, we want to deconstruct it to be able to know, well, what has to be shown before we can say that it's sufficiently reliable to be able to use in the determination of cases, civil and criminal cases. So we talk about adequacy of data input, the reliability of the methodology, and whether the methodology has been reliably applied. We talk about error rates. We talk about whether it's been tested, whether it's been subject to peer review analysis, whether the methodology used is recognized by others in that area of science and technology as being sufficiently reliable. And we love to have this kind of hard quantitative support for the fact that we can use it. But the trouble is that with AI, we are just at the very beginning stages of determining what standards are minimally acceptable for AI, which is sufficiently transparent and sufficiently reliable. And those are beginning. In the United States, for example, the National Institute of Science and Technology, which is abbreviated as NIST, highly respected scientific analytical arm of the Department of Commerce, has recently gone to the American Association for the Advancement of Science and asked them to help develop various benchmarks for trustworthy AI to be used in judicial decision-making. And there is a panel of data scientists and computer scientists and those in the judicial area who have been working on those standards. I am on that committee. And those standards will come out, but we're still, at least in the United States, several years away from having standards that can give us that confidence that we have adequately determined validity and reliability. This is going on, I think, maybe at a more accelerated pace in other parts of the world, in the EU and maybe elsewhere. But this notion of certainty versus expediency is also a tension that we see in artificial intelligence. And so these are some thoughts that I have about what tensions there may be with this promising new technology and the legal values that have shaped systems of justice throughout the world. Thank you.
Wonderful, Judge. Thank you. And now we're going back to Professor Ash, and I'll ask him how can we reach algorithmic fairness when the data that is used to train algorithms is produced amid biased societies and therefore might reflect this underlying discrimination. Would you talk a little bit about this for us? I'm seeing that you're sharing your screen, but I can hear you. I think you're on mute.
Is that working now?
It is.
Great. Thank you, Judge Ferrari, and thank you, Judge Grimm, again, for the really nice follow-up to many of the issues that have come up so far. I wanted to bring things again to an example context. A lot of the issues in kind of AI fairness and AI bias have come through in general terms, but another example of the value of open data is the Wisconsin Circuit Court's access data set, which has public case records and docket information from 72 county courts starting from the 1970s. through this data service, we were able to compile 11 million case records, or 2.5 million criminal case records, including information on the defendant, the name, different identity characteristics, as well as the associated judge and legal officers, and really detailed information on the cases in terms of bail hearings and amounts, sentencing, probation, incarceration, parole, and many other events. And this is going to help us get at predicting recidivism, or predicting probability of recidivating in exactly the way that Judge Grimm was talking about. In this previous paper with Nian-Yun Lee and Naman Joel, we analyzed a lot of the kind of issues that have been conceptually discussed about issues of data and issues of potential bias in the data, getting into these recidivism risk predictions and what the potential problems that could be caused by that if you try to use this for decision making. So we built a recidivism model and looked at a variety of different features, including current offense, criminal history, some characteristics and age, and then trying to predict, as is done in these standard approaches like COMPAS, is trying to predict if the defendant is rearrested or is back in the criminal justice system within 2 years. In terms of the machine learning algorithm, this is, I liked what Judge Grimm said earlier about actually, these are extremely complex sets of rules, go this way, go that way. XG boost, or extreme gradient boosting, is that. It's actually a complex collection of decision trees that split on different values of predictors, and is known to get state-of-the-art performance on recidivism risk prediction and other related tasks. That being said, it is, I think this is the best way to do this prediction, but it's not, that accurate. It's like 65%, 70% accurate in predicting whether a defendant will commit more crimes in the next 2 years. What we can say is that it ranks the defendants quite well, where if you're in the top decile of recidivism risk, according to our algorithm, you have, let's say, 75% chance of ending up in the judicial system again. If you're in the bottom decile, it's less than 20%. And so it really can identify people who are at higher risk, but for any given individual, the accuracy is not that high. It will make many errors. So you aren't going to want to make decisions just based on this, right? As Justice Singh said earlier, to the extent you want to use these tools, it's going to be supporting a human decision maker, adding more information and helping to organize it. I wanted to point at some of the issues of bias that come out of this data set and analysis. If we rank the defendants by their recidivism risk, we can see that across the distribution, African American defendants are put in jail at a higher rate than the other groups. So I think this is kind of helpful from a social science or policy perspective, because we can see that, to the extent there are these disparities in decision making towards different groups of defendants, it's not just because they have a higher risk of incarceration, at least according to our machine learning model. So judges or the justice system more generally are using some additional information to make those decisions, resulting in some large disparities in jail rate. I also wanted to, so this is like, some evidence of some potential human bias, but I also wanted to point to machine bias. In this paper with Lee and Joel, we considered how changing somewhat arbitrary aspects of the training data could have really large consequences in the outputs of the model. So if you just use data sets from different years, you get very different accuracy. So like this is like 2001, 2002, up to 2014. And not only does the accuracy or error rate differ over time, the relative treatment of different race groups in the data change. So for example, if you use data from the early part of the sample, you get higher false negative rates for race minorities. But if you use later years in the sample, you don't see those differences. And so the fact that kind of disparities and algorithms could change by these, somewhat arbitrary differences in the data, I think give you some pause and how they're constructed, and will motivate, you want to ask some careful questions, not just about our kind of open source algorithm, but also, of course, the private sector algorithms, which they might be difficult to audit due to these trade secret issues. So, just to wrap up, both humans and machines can be biased, but I hope that this short presentation has exemplified how AI tools can also be used to diagnose and hopefully mitigate those biases for both humans and machines.
Thank you so much, Professor Ash. And I think that Judge Graham and you brought insights on a question that is one of the central questions. That is, once we realize that even algorithmic decision-making makes errors the same way that humans make errors, in which fields do we want to, do we accept the errors that are a result of a machine, and in which areas should we only accept the errors that are made by humans? I mean, in which fields we prefer to have a human judge making an error and we wouldn't accept a machine making mistakes. I think that in the criminal field, especially when we are talking about freedom, we're in a forbidden area for an algorithmic decision making. I don't know. This is one of the biggest discussions that we have nowadays. And also, once we realize that there is bias on data, how should we intervene? I mean, which would be the best technique of data messaging to clean this data of this bias? This is also an open question. And to go on with the discussion, we're going back to Justice's side, and I would kindly ask him, how do Indian courts deal with social cleavage, like gender, religion, socioeconomic status, and caste? And how in India do judges try to treat everyone equally under the law?
That's a very, very basic question. So as far as I told you, I mean, as far as I see and what my experience has shown me, in the judiciary, in the judicial system, our constitution, the very fact that we devote the judges from the subordinate, from the trial courts, devote so much of time on the cases, just kind of ensures that it is devoid of at least I mean, that is the endeavor, that it is devoid of bias, it is devoid of partiality, it is devoid. So that's an ingrained. I mean, why India? That's a common thread through all judicial systems. The idea is to do justice, and the justice cannot be done if there's an element of partiality, if there's an element of bias. So as far as that is the oath every judge in the country takes, and according to me, every judge lives by that oath. So absolutely, I mean, I have no doubt, even for a 0.1%, that is the basis or the basic trait of any judicial system. Absolutely, I have no doubt on that. So I mean, human error is something which is, again, when humans are sitting, they make errors. There is a hierarchy of courts. The errors are supposed to be corrected at the higher level, but otherwise, I have in my experience, as I told you earlier, I have not come across any instance of bias, partiality. But yes, views, your convictions, they definitely come in the play, because you see, you have to decide, you have to adjudicate. So definitely there are your views which will help you to adjudicate. So that is what I feel. So
thank you, Justice Said. And Vlad Grigorescu has brought something to the discussion on the chat. He said, hello, don't you think that to eliminate any error, we should use the software only to identify ideas, reasoning, solutions, at least at the beginning, for us professionals to check and avoid using the software for making decisions? And his suggestion is something that many people highlight, this idea that we should have a human on the loop, always, like a human instance that would review or that would adopt the last decision. But when we talk about the human on the loop or the judge being assisted by an algorithm, we should always remember what is called machine bias, a human tendency to adopt the solution that the algorithm suggests. Just because we feel this decision that the machine is suggesting as a scientific decision. So putting a person to the side at the end of the process does not solve all of our problems because of the situation. We see the solutions that algorithms, that machines tell us that we should adopt as scientific ones, but as we have seen during this morning in Brazil, afternoon in other places of the world discussion, machine decisions, AI decisions, they're not properly scientific because they're based on data, and this data might be biased, might have mistakes, might have incorporated like these human aspects. Not only the data, but the way you program algorithms in a way brings your view. So it's not a solution that would solve all of our problems, but it is one of the ways that people suggest that we should proceed, at least in this initial moments that we are adopting AI to take more intrusive decisions, let's say so. Okay, so now we follow our discussion, and I would go back to Dr. Angeline Waireghi, and I would ask her a broad question. I would ask her what she considers to be some of the specific legal values that are attention by AI in the African region, but also how data centricity can help empower African citizens and communities. So the bright side and the bad side.
Thank you. I think I'll start with the tension question, because I think most of what we're seeing on the continent has already been touched on, and it mirrors decades of illegal tensions that have been here. So what we see with technology is it tends to either, or what we've seen globally, I should say, with technological revolutions, it either tends to classify or calcify, I should say, existing inequalities or widen those inequalities. And I think the fear is that AI will behave in much the same way if we don't take steps to prevent that or to mitigate that. So again, what we have in Africa, speaking in generalities, is we have this disparity in social economic resources. And that is on a high level and also on a granular level. There's sort of a trickle effect, a trickle down effect. So if you're higher up in the social economic ladder, it means you have access to education, right? And if you have access to education as a whole, and you have access to better education. And that means in this better educational institutions, you can get training in digital and data math. matters. So how to use computers, coding, all that stuff. So what tends to happen is two things. One, from the end user, you'll have a certain segment of the population using and benefiting from these tools, whether it's AI or ICT tools as a whole. And then the back end, you'll have a certain segment of the population that is involved in development, and they carry that bias within that population throughout that process. So we did a study at CIPIT a while back, in 2020, that was looking at the gender disparity within the emerging AI workforce. And what we saw is, one, it kind of mirrors the global gender disparity in tech, but it's a little bit worse actually. And it tends to get worse as the positions of power. In the higher seats of power, you find that 90% of the people in those seats of power are men. And they're men from higher economic levels. And that really affects how AI is developed. If you, for example, don't have women in these conversations around how they're developing these tools, then a lot of the factors that go into developing them, a lot of the factors that should be questioned or voiced or concerns by women, I'm just using women as an example, those are not really raised. And it's sort of, it would be naive to think that this would not be the same thing that would happen if we were to develop local tools to be deployed within the judicial systems, right? So we'd have to make sure that this was really inclusive. Again, we have issues of resources in terms of digital infrastructure. There has been a push by the Kenyan government to make sure that we don't have such a disparity, such a skewed digital development between the rural and urban areas. But even now, we still see, even if we look at just like mobile tools, in the urban centers, you have 4G towers for mobile tools, but if you go to the rural areas, you have very few of those. So yes, there's been a lot of mobile penetration in Kenya, in Africa in general, but you see that there's also a disparity in the types of mobile equipment that people have access to and that are available. So if we're going to say we're going to deploy this AI tools for use in the judiciary to ease access, okay, that's great. And we might even make sure that these tools are mobile, they can be used in mobile devices, but is it really realistic if you have people in the rural areas who only have access to 3G mobile devices, right? That's problem number one, and they barely have internet connectivity. Is it really realistic to think that this would ease with their issues in getting justice? So that's a concern as well. The other concern is, and then I'll move on to the issue of data centricity. I guess the power asymmetry in terms of, we believe, and there is evidence to show that as a whole, justice is carried out fairly evenly, but even getting to the legal system is a matter of justice, in that it costs money to hire a lawyer, right? It costs money to take time off to go into the court systems. And we can't really be sure that there isn't bias in terms of people who are politically connected or a little bit more higher up in the economic strata, that doesn't carry some weight in how whoever is deploying this justice views this litigants and how they rule for or against them. So what would be the guardrails that we would enforce with these AI platforms to make sure that those attitudes that are prevalent or that prevail in our legal fields right now don't carry over into this AI legal world that we're building, if we had human, even if the human factor was input into that, meaning that you have human people looking at the laws, at the ruling, that these platforms come up with and are the final vote. I'm not sure really that does anything, as Justice Ferrari had said, because you still have your bias. And the other thing I worry about is that using these systems right now, using the systems like the recidivism platforms, even knowing all the problematic portions of it, what it does, I mean, if you have that in mind, knowing that this is biased, there's still a certain aspect of bias confirmation, right? It's telling you what you already believe. So that just kind of calcifies whatever you already believe. And then that's can have really detrimental impacts to people who are vulnerable groups. So I think that's a question I still have. Would not the ethical thing be to put a pause in using the systems and sort of work on them outside of the legal field before we bring them in? But you know, that's an argument that we can make for and against. In terms of data centricity, I think that is a really, really important factor in making sure that bias, as much as it can be, is mitigated, making sure that there's equitable distribution of these benefits. Because data centricity is this revolution that data is the most important asset of these applications, right? And if we make data the most important asset, then what we can also do, take it a step further and make sure that the methodology of creating this data sets is also sort of like a high priority factor. And I think the best way to do that would to really, really, really push this movement of localization, so localized data creation. So data is very global, and that's great, and access to that data is great as well. But I think there's something to be said in creating sets locally, because in theory, those data sets would reflect the environment and the people a lot better than data sets imported in or data sets accessed in other ways. So I think creating localized data sets and using those specific localized data sets to train the algorithms may go a long way in making sure that they are unbiased as possible. And, you know, if it's unbiased, then the theory is that it's a more equitable use of those systems. So data localization, I think, is something that needs to be discussed a lot more in terms of data creation and data centricity. Another thing is data ownership, which is a discussion that comes up, but I think is a little bit fraught because we are we're really eager to champion globalization in all aspects, and that's not a bad thing. But I think the worry is if there is a power imbalance that exists in terms of experience, in terms of I guess, leverage, for a lack of a better way of saying it, in terms of a bigger stick, as it were, when you look at things even nationally. So regions in the global South versus regions in the US or the EU or the UK, you know, an argument can be said that when we're looking at these things like trade agreements or international trade agreements, the leverage is not with us, right? So when we have these rules and we set the standards and their global standards, I think we really need to be careful when we are looking at them to make sure that their impact is beneficial to those with the smaller stake, as it were, with the less leverage. Just data ownership is something that I think we need to fight for, that we own our own data and then we can choose to do with it as we please. And that could be, you know, sharing it, or it could be holding it close, and, you know, see how that pans out, which is really not the case right now. As I said, right now as a whole, again, general statement, but Africa, we tend to export data out, and we export it with very few strings attached, either because we can't attach those strings, or, you know, maybe it's just not a conversation that has been had. So data ownership, I think, is something that we need to look into, in terms of also the use of AI in the legal systems. Once we input that data in there, you know, what's happening if we're using imported platforms. So I think there is a lot of positives a lot of positives to using AI across the board and using AI in the judicial system. For example, in Kenya, we had a massive backlog of cases, but with the implementation of ICT technologies and some of those are AI-enabled tools, we've seen a significant reduction of this backlog. But I think we really need to be careful not to buy into the silver bullet narrative with AI, especially because that narrative, the genesis is not really with us specifically in the global South. So I think we need to be critical in our application of these tools and just really question why we're using them, how they can benefit us, and even maybe just ask whether we should be using them. You know, I think that's something that people shy away from. The consensus seems to be jumping right into we should use them and they will XYZ and then interrogate that. But maybe we need to take a step back and just say, on a global level, if we're seeing bias in tools like the recidivism platforms, should we still employ them? And then maybe on a more specific level in Africa or in the global South as a whole, if these tools, if the narratives, if the technology itself, if all that is being imported to us, maybe we need to take a step back and really see whether this is beneficial for us to use and then go from there once we have our answers. Thank you. I hope I didn't run too long. Thank you.
Thank you, Dr. Iregi. And I'm using the last minutes we have to address some very interesting questions that we have on the chat. The first one is from Ms. HLI. She asks, I would like to have your opinion on a case of AI ethics, promotion of a robot as a CEO of a company. And I don't know if the other panelists have something to say about that, but before getting to any discussion of like liability of a robot that works as a CEO of a company, what I would highlight is that the state of AI that we have nowadays, that is weak AI, does not allow us to deliver the activity of being a CEO of a company to a robot, because the state of AI that we have nowadays, weak AI, is different from strong AI. Strong AI is something that resembles a lot like human knowledge or human intelligence. If you have seen that movie, Her, from Spike Jonze, it's basically that. It's something that might interact in very different ways and take decisions in very different fields. So we don't have this kind of intelligence till nowadays, and we don't know when this might, when we might have something like that. So the state of AI that we have nowadays is an AI that is trained to do a specific activity, and that being trained to do that specific activity might act in a satisfactory way doing that. So for example, we could have a robot on a company that we could adopt to make hirings, or we could have a robot on a company to do the investments of the company, or we could have this robot to manage some specific thing, but not like being a CEO that you have to have like multiple abilities in very different fields. So it's not something that nowadays is realistic. Okay, I don't know if someone else would like to add something to this discussion. If not, I would go directly to the very interesting questions that Professor Ash have brought to the judges on the panel. He asked, what types of explanations for machine learned predictions would be most useful for judges? Would it be useful to know how accurate is an algorithm or how confident it is in a particular case? Would it be useful to know what features, characteristics it usually uses for the prediction, or what characteristics are pivotal in a particular case? If an algorithm was adjusted to make it fair towards some groups, would it be important to know that and to know what adjustment was made in a particular case? And I would give the floor to the panelists, but before, I would just like to highlight something about Brazil. As I mentioned before, we have 64 projects of AI in the judiciary today in Brazil, and the National Council of Justice that is responsible for the implementation of these programs has made like a panel for everyone, not only judges, but for everyone. And in this panel, the National Council of Justice brings information that everyone can understand on, for example, what is the origin of the data? Is it like public data? Is it private data? Can the technical team explain how the inputs became the outputs? Can the non-technical team explain how the inputs became the outputs? And what is the region? What is the court? How long it was developed? What is the technique? What does it do? What is the objective? So this kind of informations help us to clarify some points, because as Siegfried mentioned here, to deal with opacity, there is a new field that has been developed and has gained traction in the last 2 years that is called explainable AI. So you use algorithms to explain how other algorithms are operating. But one of the problems of the explainable AI field an explainable AI is a field of basically computation, is that when you take one of the papers where they bring the explanation of how that algorithm is working, like we people that are not from the programming field, we don't understand anything. And that's not the information that we judges need. We need just to understand how has the data been selected? What were the main decisions? What is the objective? Has it been trained? Has it been tested? Is there any difference among ethnical groups, for example? So one of the tasks that we, the men of the law, the men and women of the law, and the society itself have, is to tell programmers what kind of information we need and how do we want to receive this information. And then that's exactly what Professor Ash asked, because if you take a look at the chat, someone here asked us, so judges, do you think the equalized odds is a good fairness criteria? And that's exactly the problem. We can talk in this line of programming words. We don't have this vocabulary. So how should we bring this to our reality? I would love to hear what the other panelists have to say on that. I don't know if someone wants to take the floor to say something.
I'll jump in. Fools rush in where angels fear to tread. I will. I don't think. First of all, I think all of the questions that Professor Ash poses as would it be helpful for judges to know, the answer to all of those is yes. I think that Judge Ferrari has done a superb job of capturing the list of things that we don't know that we need to know before we can use artificial intelligence in a way that we don't want to approach artificial intelligence with genuine stupidity. So we need to be smart in terms about what we are seeking to use artificial intelligence for. And I think that you have done a superb job of sort of capturing that from a broad perspective as well as a narrow one. But the key is that all technology is designed to do something. There are parameters under which it does it. It has been tested using certain data, and there is no such thing as a perfect outcome. And so the types of questions that Dr. Ash says, would knowing this software was developed for this purpose. It was done under these parameters. It was done, tested on this population, but not as for that. It was designed for this particular function, but not for this another function. That would all be helpful to be able to be used at it. But I think that the point that Judge Ferrari made that is so critical here is, and I thought I saw on the scroll someplace, someone said that strong AI was a fallacy. I think that in today's environment, I think most people think that there are a large number of data scientists that believe that strong AI will never exist because the mechanisms by which human decision making takes place are so complicated. We still don't even know how the human brain works. We're still learning more about that and neuro functioning these days. So what we have is we have weak AI. It may be stronger AI because it has multiple different levels of being able to be used. But the day that we can substitute human involvement, particularly where the outcome is very, very critical, is maybe best reserved for science fiction at the present time. I think that coming up with some standards that would help in terms of just how transparent AI must be. I like the idea of explainable AI, but there are some things that you can't explain, but they are accurate. And that gets into some of these biases that we've talked about. Automation bias says, well, it must be right, a computer did it, to AI aversion, which is, oh my gosh, we can't have anything to do with this because a human was not involved. We're just getting started in this. The questions that have been asked and the observations that have been made during this program are really superb because it shows that we're now beginning to understand in a much better way what we don't know. And that will help us to develop the proper courses to get that which we need to know for the roles that we're going to allow this to play in the judicial system.
So, of course, as we can see, we could stay here for the next 2 or 3 days and we wouldn't end this discussion. But unfortunately, we're running out of time. So I'd like once more to thank all the panelists. I'd like to thank all the attendees. And I'd like to say that it has been a pleasure to be here, to hear all of you. And I would like to give the floor to our dear Pratik again, to the last remarks, to the closing words.
Thank you, Judge Ferrari, for excellent moderation, and to our fellow panelists for a really insightful conversation. And the good part was we took 2 hours to really dive into the questions. A lot of times we tend to just stay on the surface on problems of bias, discrimination. And I know all of you have court to attend at different points, but I saw that Judge Khalid unmuted himself. I don't know if you have 30 seconds of last thoughts or we can conclude.
Thank you, Pratik. Actually, I was prepared to answer another question on the implications of artificial intelligence in relation to the judicial work. But I see that we're all running out of time and I have to open another meeting actually in a few seconds. So I think I'll take a rain check for that. And maybe in the next event, I will have enough time needed to address this point. Thank you.
For sure. Thank you so much to all of you. We'll conclude this session. We have a course on AI and the rule of law from UNESCO, which is free and available in 7 languages online. So I'll just invite the technical team to play this video. And with that, I thank all the speakers and the panelists and Judge Ferrari for joining us. And we hope to work with you and continue this dialogue globally. Thank you.
Thanks, everybody.
As AI systems are deployed across the world, their use is raising important questions related to protection and promotion of human rights and fundamental freedoms. How are judicial operators affected in their quest to uphold the rule of law in the age of AI?
What are the implications for human rights?
How can AI be adopted to improve the administration of justice?
UNESCO's Judges Initiative is at the forefront of engaging judicial systems on the protection of human rights, both online and offline. This MOOC on AI and the rule of law is a 6-module introductory course developed by UNESCO and the Future Society, bringing together a lineup of diverse subject matter experts from around the globe.
We will discuss the digitalization of justice systems and the rise of online courts.
We will also explore the implications of the use of AI on human rights with respect to questions of bias, discrimination, privacy, and freedom of expression.
Throughout the course, we will touch on examples of AI use across different justice systems and the emerging jurisprudence in the domain. We aim to have a participative dialogue and promote knowledge exchange to help you build capacities to effectively address AI issues across justice systems.
Join the debate
And enjoy our lectures.
Well, thank you, everyone. And on that note, please feel free to join the debate on this. We have the links available in the chat. And we will have the break now until 3:30 CET. So in half an hour from different time zones, wherever you are. And thank you so much. Have a good day. Bye-bye.
Hello and welcome back. For those joining us for the first time, my name is Elliot Ash, and I'm here today on behalf of ETH Zurich Center for Law and Economics. At the center, we have a diverse group of researchers working on the legal and economic aspects of technology and policy, including a legal tech initiative in collaboration with the ETH AI Center. A theme of this summit is that not only will we need policy solutions to help regulate AI, but also we can use AI tools to support the policymaking and decision-making process. And on both sides, we will need contributions from government, business, and academia. In this next session, we're moving more to the academic side with an academic research spotlight by Professor Markus Leipold. Markus holds the chair in financial engineering at University of Zurich. He held past positions at Imperial College in London and the Federal Reserve Bank in New York. Besides publishing in top academic journals in finance and statistics, Markus has done 2 stints as a visiting researcher at Google. In his work at Uni Zurich, Google, and elsewhere, Markus has helped invent a new field at the intersection of climate finance and natural language processing. And that is the title of today's talk. After the presentation, we'll have time for Q&A. So please put your questions in the Zoom chat and I will ask Markus directly when he's finished. So that's the intro. Markus, the floor is yours.
Well, thank you very much, Elliot, for this very kind introduction. I will just try to share my screen and I hope it works. So hope everybody can see it.
That's good.
So it's a real pleasure to give a short kind of summary over my journey that I have been following over the past couple of years. Elliot was rightfully mentioning that I hold the chair in financial engineering, and what I'm going to talk about has very little to do with financial engineering. It's about climate finance and natural language processing. And the first question that pops into your mind is, well, what the hell has finance to do with climate change? And in order to give an answer to that, we have to briefly visit this fellow here, which is Bill Nordhaus, who has actually won the Nobel Prize in economics for his work on climate economics. And he was basically one of the first researchers who started to understand that when you want to talk about the impact of economics on our environment and society, we do not just have to look at the usual economic processes, which I was scribbling down in my awful handwritten in my awful handwriting here. So it's not enough to just think about consumption, investment, and all these things, but we also have to think about what is the impact of economic activity on the environment. And there are many impacts. So we are basically taking out resources from the environment, and this taking out of resources generates externalities which are not incorporated into prices. But the problem here is really the feedback effect that this generates. Like our economic activity leads to rising temperatures, leads to climate damages due to physical risks like natural catastrophes and the like. And therefore, we have to think very carefully about our economic activities, which are basically financed through capital markets and financial markets. And therefore, climate change and economics have basically everything to do with each other. And how can we break down these vicious circles? Well, we have to think about climate mitigation strategies. That is, we have to put a fair price on the resources that we are taking out of the environment and the externalities that we are generating. So this is then the climate mitigation aspect. But we have also to think about climate adaptation, because now it's too late and we have to spend enormous amount of money for climate adaptation. So we have to build sea dams and things alike. And the third strategy we can follow is we can think about innovation that leads to negative emissions. So how can we extract CO2 out of the environment? So these are the three pillars we have to think about. And we have to think about that in economic terms. That means, obviously, markets are not functioning correctly. So how can you fix the market? Well, you can follow the Chicago kind of approach, which would say, well, the market will fix itself. Or we can think about putting on governmental regulation on our economic activities. And of course, the financial markets, they fear very much governmental interventions. And therefore, what we have seen over the last couple of years is an immense increase into how corporations disclose their climate-related risks and their environmental pledges and so on and so forth. So we have seen a tremendous increase in initiatives like the TCFD, the Task Force on Climate-Related Financial Disclosures, which gives some recommendations on how you should report on climate risks. And we have seen Climate Action 100+, Science-Based Targets Initiative, and corporations have started to create very nice corporate sustainability reports with a lot of pictures inside. But the big question is, do we get the information that we actually need in order to mitigate the problem of climate change from these reports? So although we see this immense increase in reporting, what we also see is an immense increase in the CO2 that we emit to our atmosphere. So although there have been an increasing number of pledges by corporations, in April 2022, we have seen new records in CO2 emissions that are measured in the atmosphere. So the big question is, therefore, have these kind of initiatives, do they have some impact on financial markets and on the capital, how capital is allocated in the financial markets? And motivated by this question, and the first time I was actually at Google back in 2019, there was this great algorithm that was invented, which happened to have the name BERT, which stands for Bidirectional Encoder Representation from Transformers. And we were applying BERT back in 2019-20 on regulatory reportings of companies in the US market. So we were looking at the so-called 10K filings, and we were asking the question whether with this natural language processing algorithms, we could actually extract information from these regulatory reports and check whether this information is actually entering financial market prices. Because financial market prices, you can think of prices as just a number reflecting all the information that are important for market participants. And what we actually saw is that the so-called CDS credit default swap prices, which you could think of as a measure of the credit risk of companies, were positively reacting for those companies who had a large exposure to transition risk. Now, what is transition risk? Transition risk is the risk for a company that is caused by potential climate mitigation strategies by governments. Let's say if they would impose, for instance, CO2 taxes for emitting companies, then a company is said to have high transition risk. And the credit risk was increasing for these companies due to the Paris Agreement, since at that time, companies and investors were realizing that governments eventually will impose some CO2 taxes on polluting companies. But then something else happened almost a year later, which is the election of Trump. And of course, when Trump came into became president, he was again stepping out of the Paris Agreement, and we actually were able to measure the impact on the financial markets from this event. So what we saw is that the companies that had high transition risk, so the polluting companies, actually witnessed a reduction in credit risk. So motivated by these results and by the power of natural language processing methods, I, at that time, went on and studied further problems, which not necessarily had to do with finance. So I was looking into fact-checking algorithms. I was looking into generating databases for climate-related claims that can be then later used also for fact-checking. And I thought that this experience with the fact-checking algorithm could actually be used to do fact-checking in an economic environment. But here it's not called fact-checking, but it's called greenwashing. And inspired, of course, by my experience as a kid watching the Muppet Show, there was once Kermit singing a song to Miss Piggy, and the title of the song is, or was, "It's Not Easy Being Green." I thought that, okay, looking at greenwashing detection could be something very important. And why is it important? Well, you all remember this young little girl that was spearheading the Fridays for Future initiative, and everybody was laughing at it. I recall that Mnuchin, when he was in Davos, was basically making a joke of her that, well, she should go back to university or start first university and study economics, because economics and climate has nothing to do with each other. But we saw over time quite a tremendous change of business leaders who started to take this initiative actually quite seriously. And the question is, why did they take it seriously? Because they think that climate change is indeed a problem and that we have to change our economic system accordingly, or is it just a marketing tool to attract new customers and new generations? So what we see in the press and in the news is all these business leaders, for instance, Larry Fink from BlackRock with his famous letter to the CEOs saying that, well, from now on, climate change is something very important for BlackRock. And we see, for instance, from JP Morgan Chase, Jamie Dimon, who also started to embrace a policy for CO2 taxes in the US. Or we saw Bernard Looney, who actually pledges net zero carbon emissions by 2050. But all these nice pledges, they started to get some cracks. And the main reason for that was a kind of an earthquake that happened back in May 2022 of this year. And that was actually Stuart Kirk. Stuart Kirk in May 2022 gave a talk at the Moral Money Summit organized by the Financial Times. And he was the head of responsible investments. And his message was basically, well, you know, he's getting tired of all these talks about climate change. We have bigger problems to deal with. And in any case, who cares if Miami is 6 meters underwater in 100 years? Amsterdam has been 6 meters underwater for ages, and that's really a nice place. So we will cope with it. This, of course, raises a lot of questions. So how seriously are these industries really taking on the problem of climate change? And probably Stuart Kirk, who is actually a very nice guy, I met him personally and had the chat with him about 3 weeks ago, and is of course now no longer employed by HSBC. So he's currently on the market, so to say, because he was kicked out a couple of hours later after his speech. But the big question is, how seriously are these pledges really made? And this is what we wanted to tackle. So we wanted to address the question, can we find ways to analyze this amount of corporate disclosures and statements in the news and so on and so forth using natural language processing, because a human cannot do it anymore because the amount of text is just too big. So for that reason, we were actually creating ClimateBird. And ClimateBird is basically just a extension of the BERT model, who was then pre-trained on around 2 million paragraphs of climate-related texts from news, from scientific papers, and also from corporate sustainability reports. And with this algorithm, we were able to ask a lot of interesting questions. So for instance, we were analyzing in a paper called Cheap Talk and Cherry Picking, we were analyzing TCFD reports. So the TCFD reports is basically a framework for companies to disclose climate relevant information in 4 pillars. One pillar is governance, the other one is strategy, the third one is risk management, and the fourth one is metrics and targets. And we were looking in which categories companies like to report the most. And it turned out that companies really like to talk about strategies, because in the strategy category, they can talk in very broad terms without the need to become very specific of what they're actually doing, compared to the metrics and targets, where they have to disclose specific commitments if you want. And so therefore we call this actually cherry picking, because companies are cherry picking in which category they want to report. And then we were looking at the following problem. So we tried to train ClimateBird to identify the commitments companies are making to address climate change. And we just didn't want to look at commitments, but we wanted to look at specific commitments, because in the end, the decision useful information that companies provide are exactly in this decision in this specific commitments. At the ratio of non-specific commitments to specific to all commitments, we christened that the cheap talk index. And the more cheap talk the company is making, the less informative the reporting on climate-related risk these disclosures are. And if you want to look how this has actually changed over time, so we were looking at almost 15,000 annual reports from the MSCI World constituents. And we first looked at how the number of commitments are changing over time relative to the year 2010. It's fair to say that back in 2010, companies were not yet really much engaged in reporting climate-related issues. And you see that the commitments companies are making has increased by 20% over these 10 years. And more worrying is actually the amount of cheap talk that you find in the annual reports by these companies. It has increased by an amount of almost 80%. Now, this is the MSCI World constituents, and these are companies in different sectors. So we also looked at just the financial industry, and oh no, I'm missing that one. Sorry about that. So therefore, I'm going to tell you in words what we see in the financial industry. If you recall the previous graphic, the amount of commitments in the MSCI World, which has different sectors, increased by 20% over the 10 years. And for the financial industry, the climate commitments increased actually by 150%, which is, of course, much larger. And it has actually increased quite steeply after the Paris Agreement, right? So We were also writing other papers where we developed a database on environmental claims. This is also very important if at some point we want to go into that direction where we do AI-based greenwashing detection. So we have now an algorithm, and we trained then ClimateBird on the database that can identify environmental claims in any document. So whether it's news, climate report, corporate sustainability reports, press releases by companies, annual reports, and so forth and so on. We have an algorithm that can collect for a given company all the environmental claims that have been made, which can then be fact-checked against an evidence base. What we also have been looking at is some further extensions of current algorithms that helps us to generate actually these kind of claims. So I think I have 3 minutes left, so I'm gonna skip this slide here. One last thing that I want to briefly talk about is the current language models, these large language models, which have been also in the press for a while now. These are very powerful models that can actually generate text, or you can communicate with this language model. And depending on how these language models are trained, you get actually very interesting answers. That led me to an experiment that I did. So I was doing an interview with a large language model, which is GPT-3, and I was asking different questions related to climate finance issues, and the answers that I got were quite astonishing. So you will find the whole interview at this link over there. So I was, for instance, asking the following question: is a carbon intensity reduction of 4% per annum for an investment portfolio aligned with the goals of the Paris Agreement? And you have to remember that these large language models are not trained per se on giving an answer to climate-related questions. So this is really a very generic model. And the answer that was given to me was, no, a carbon intensity reduction of 4% is not enough, because the Paris Agreement calls for a 2 degrees Celsius above industrial level. And therefore, actually, emissions have to be reduced by 7% per year. So this is quite astonishing, because this 7%, if you do the fact checking on this answer, is actually the correct answer. So you see that these natural language processing models are already quite advanced. And of course, I was asking the question, is climate change a problem for humanity? And the answer was unfortunately not that good. I mean, not that good for humanity, but very good from an NLP perspective. There is no question that climate change poses a serious threat to humanity. The IPCC has warned that we must take urgent action to reduce greenhouse gas emissions if we were to avoid catastrophic temperature rises. The effect of climate change are already being felt around the world, and they are only going to get worse unless we take decisive action. So this was quite astonishing for me, and I think therefore there's quite a lot of potential doing research in the direction of large language models, because they have still some deficiencies that needs to be tackled. So they have to be grounded in a ground truth, and this is currently what I am working on. So I think that's it from my side. So I'm happy to take questions.
Great, thank you, Marcus. I just opened up the Zoom chat for questions, but I have a couple while we're waiting. So first, in the area of climate claim verification, do you make a distinction, or is it important to make a distinction between scientific facts about the Earth's atmosphere, so chemistry and physics, like about meteorology or atmospheric science, versus causal claims about human interactions with the climate? Do you make a distinction in those in your data set or your your checking models?
Well, for now, everything I was presenting was more like fact checking in the social sciences. So it has not necessarily to do anything with natural sciences, which makes it, of course, much harder. There is, of course, kind of a agreement by climate scientists that humans are the cause for climate change, and this agreement stands around above 97%. So in economics and finance, if you have scientists, 3% of the scientists that agree on something, that would be already kind of exceptional. Just to make a small joke here, but it's of course much more difficult. What we are looking at is really at the greenwashing definition. And me as a researcher, I'm not necessarily trying to define what greenwashing is or should be, because I think that's kind of a societal question and is defined eventually by the regulator. But given that decision, or given that definition, I can use NLP to check whether the corporate communication is actually in line or not in line with this definition of greenwashing.
One quick follow-up to that. Do you in greenwashing, would it be as effective if you just without even fact checking against an evidence base, if you just looked at whether statements are verifiable or not? So is there like a numerical threshold given versus something like more vague?
Yeah, so that's a good question, and this is the next step we are looking into. So we want to differentiate between factual versus non-factual claims, and then of course, if you have, for instance, claims about emissions, because we have this voluntary reported emissions and we have estimated emissions. I think the big vision in this direction is to have a kind of a combination of textual analysis of what companies are reporting in terms of their emission versus the analysis of satellite data and using information regarding physical assets of the companies. And these are different pieces that we will actually try to put together over the next 2-3 years, I would say, but that's a big research agenda.
That's great. There's a couple of questions in the chat. The first is, do you think it might be important about giving legal rights and protections to non-human entities like animals or trees or rivers, things like this? Will this have some efficacy in climate change policy and outcomes?
Well, that's that's a good question, and I'm definitely not an authority to provide an answer to this question. Maybe it will help, but I think it's not really related to what I'm doing here, but it's a tricky question. I don't have an answer on that one.
And another question, which actually might be related to what I was asking earlier, is whether you observe a relation between cheap talk and hard economic commitments by company.
Well, the cheap talk is basically a measure of how much information that you get from disclosures that are actually not useful for you as an individual to make a assumption. So in that sense, it's I give you an example. So for instance, I was talking to a very large asset manager here in Switzerland. Of course, I cannot give names, but the head of sustainability was telling me that, when I do a corporate sustainability report, I have my writers that send me the first draft. And then usually I send it back, telling them, well, you have to adopt vague language. Just write very vaguely. And he told me that he does that about 10 times. So I asked him, okay, why are you writing these reports? Because if you just adopt vague language, it's not useful for anybody. It's just a waste of time. And he said, well, the regulators are asking me to do so. So therefore, I think that it's very critical that both sides, the regulators as well as the companies, have to decide on which information they actually should provide in these reports. For me, it currently seems that not even the regulator knows what kind of information the companies should report. They should just report on climate change and climate risk. And the companies, they really want to provide information in a way that they cannot be held accountable for providing misinformation. So therefore, they adopt very vague language. And that's what we see in the data.
Great, thank you. And one final question. Do you think there's something special, and maybe you actually implied this earlier when you said this is actually a hard task in the social sciences, but do you think there's something special about climate change or climate policy that makes it amenable to natural language processing technology? And is this an easy or hard case relative to other types of knowledge? And maybe natural science would be one, but other kind of technical domains like medical knowledge or legal knowledge, for example. Do you have thoughts on that?
Well, I think climate change is probably one of the hardest topics. Maybe also, let's say, pandemic is also something very, very hard. Why is it hard? Because you have scientific evidence, but the scientific evidence actually has a direct implication on our society and on our life, right? So if you think about the scientific claim regarding some I don't know, astrophysical phenomena, it doesn't change your life, right? But climate change has a direct impact. If you have taxes, it will reduce your income. If you have different climate policies, it will change your life in a very dramatic way. And therefore, I think it's very interesting because the scientific evidence is here. So we all know that the sword of Damocles is upon our heads, and we have to change. And even more problematic is that climate change still is kind of a medium long-term problem. So it's not something that we feel right now, like the pandemic. And still we need to change our attitudes, our life for future generations. So this makes it super interesting. Unfortunately, super interesting for using scientific methods to analyze the problem across different dimensions, from scientific dimensions to a societal dimension.
Thank you, Marcus. That's a nice place to leave it. So we'll conclude this session with Marcus. Thank you very much.
Thank you for having me.
And we'll now go to the next session with Deep Judge and Paulina Gurnerova.
Very warm welcome, everybody, to this session with Nidhi Singh, who is JSM and Spills Fellow at Stanford Law School and Counsel at the Supreme Court of India. Nidhi has been enlisted as the top individual lawyer on Forbes India's legal power list in 2022, as well as the most admired global Indians in the 2022 by Passion Vista. And she's also the recipient of many awards, including the Lex Falcon Award for Emerging Lawyers in India in 2022. Now, you can find a link to Nidhi's impressive CV on our event website. And Nidhi today will be sharing a presentation with us about the role of AI technologies in improving the productivity of the Indian judicial system. So our session will last about 20 minutes. So I do not want to take too much of the time already. Warm welcome, Nidhi, and we look forward to your remarks. So the floor is yours.
Yeah. Hi, everyone. Thank you so much, Aisha, for having me over and for giving me this opportunity to share some of my research, some of my work that I've been doing on artificial intelligence and its role in improving the productivity of the Indian judicial system. A lot of it is at a nascent stage, but it'll be helpful to share some of the findings that I have gathered through various forums and through various research and through various interviews. So the idea of this is sharing of experience that I have in terms of the role of artificial intelligence technologies in improving the productivity of the Indian judicial system is that I would like to first start with giving you a brief background about what Indian judiciary looks like for the international audience, and it'll be helpful to get some sort of an idea with respect to that. So if you look at the judicial delays, which is not only very, I would say, sacred to India, but it's something where you see it up in many jurisdictions. And eventually, when I proceed, I will be taking some examples also from the US courts to give you a comparative analysis. Now, if you look at the judicial delays and backlogs, they have as such plagued the access to justice in India. And when I was trying to conduct a research on this, trying to do an empirical study, I wanted to examine whether the AI technologies which have been introduced or adopted since 2019 by the Indian judiciary has somewhat improved the overall judicial productivity. I tried to assess this by calculating the ratio of the judges to the number of case disposals that they were doing per year before and after the adoption of the AI technologies. Tried to identify a little bit the challenges that the judiciary faces to address the problem of the backlog of cases. And what were the globally available AI technology that were equipped enough to address the problems of you can say the problem of backlog cases with the help of technology prevalent in India. Now, to be very briefly, if you look at India has a population of around 1.4 billion people, a sixth of the world's largest population. Therefore, it comes no surprise that more than 47 million people, more than 47 million cases are pending across various Indian courts, be it the lower courts, the district courts. And if I quote the data from the National Judicial Data Grid, it says that around 41 crore 979,353 cases are pending before various district and subordinate courts. So even before I begin how the AI can apply, AI is the need for the Indian judiciary at the moment to reduce the backlog of cases. What is the reason for this judicial pendency is also because the judges to population ratio is quite low. There are not enough judges to hear and decide cases. And if I quote the Indian Justice Report of 2020, India has approximately one judge per 50,000 citizens. And moreover, some states like Bihar, West Bengal, Telangana, Uttar Pradesh, these are some of the eastern states in India, which have almost one judge for every 1 lakh citizens. So you can imagine the how burdened the judiciary is which also affects the overall administration of justice as well. And if you look at the case management thing in India, so for a considerable number of cases that you look at, there is an inadequate preparation by the lawyers also, which results in adjournments or delays, or somewhat an inefficient utilization of a judge's time, and cognitive resources that result in the overall judicial productivity as such. And there is also a problem, that the property rights in India as such are not very well defined, and a considerable number of cases concerned to that. So the problem of the backlog of cases keeps increasing. Now, given this background, what is it that India is doing to solve this problem with the usage of the AI technology? Some examples that I want to bring to your notice today is that Supreme Court has launched an AI system in 2019, and this is Supreme Court of India I'm talking about, to improve the access of justice. Now, the system which they launched it was called the Supreme Court's Vidhi Anuvad software, which is also called the SUVAS software. The idea is that the system is trained to translate English judicial documents or orders and judgments into 9 vernacular languages and scripts and vice versa. So this is one step in this regard. The other step is that the Supreme Court portal for assistance in court efficiency, which is called also the SUPACE, SUPACE, it was launched very recently, like last year in 2021. Now, this software that I'm talking about, it was designed as such to understand the judicial process that requires some sort of an automation. So what it basically does is that it assists the courts in improving the efficiency, or you can say productivity, by collecting the relevant laws, the legal acts, the statutes, and the facts, and they make it available to the judges who sit on the bench. What this basically does is that it helps the judges reduce the workload. So SUPACE does not decide the case. Therefore, the judges will have the full discretion and autonomy to decide the case in a somewhat faster pace. But this is an aid to, you can say, to improve the judicial productivity in India. Now, very briefly now, if we talk about artificial intelligence and machine learning, we know that it's an adaptive computer program which can perform functions that is typically associated with the human mind, and it offers some sort of a new opportunities for improving the productivity of large-scale organization. And the recent advances in the data collection, or you can say the system aggregation, algorithms, all of this processing power have transformed the computers from machines that perform, say, a rigidly defined task, to machines that can learn even without supervision and adapt to new inputs as such, you can say, without the need to be reprogrammed. So the idea is that AI offers a myriad number of ways to improve the justice system. And the large volume of data from surveillance system that you would want to collect, or for that matter, the digital payments for platforms, the newly computerized bureaucratic systems, and even the social media platforms, all of this can be analyzed to, detect the anomalous activity, or you can say investigate the potential criminal activity and improve the system of justice. AI systems, if you look at in improving the access to justice, what I found that is that it can reduce the barriers to also accessing courts by providing, say, users like you and I with a timely information that directly, rather than you going through the channel of the lawyers. For example, in the United States, the AI is already used in processing of bail applications, DNA analysis of crimes, gunshot detection, and even crime forecasting. And very quickly, in brief, I want to give you example of United States. If you look at the way, the applications have been processed in the US courts, for example, it finds that for instance, the tone of words used in the first 3 minutes of a hearing, or say for that matter, the incidence of birthdays, the outcomes of sporting events, and even the time of a day of a hearing, all of this affect the outcome of the cases. And these methods can actually identify both the conscious and the unconscious bias. The analysis of, say, around 20,000 judicial rulings collected over 77 years period of time by the 12 US circuit courts, all of this, they illustrate that the judges demonstrate somewhat considerable bias before the national elections. Similarly, there is also, and this is not something which is a very absurd, because the fact that the US Constitution does not have a provision for appointment for judges, rather it's more of a political appointment. So this comes as a no surprise, even with the usage of AI when you come across this finding. Similarly, there is new evidence that suggests that sequencing matters in high stakes decisions or decisions made on previous cases that also affect the outcome of the current cases, even though the cases have nothing to do with each other. So somewhat even the US judiciary, which has been quite proactive in using this application, there is some sort of a bias that you see in the rulings, which also has some sort of the negative consequences of having usage of AI in the judicial system. Very quickly, coming to the Indian judiciary, to give you a comparative study in that respect. In the past 15 years, if you see, the considerable efforts have been made to adopt and deploy information technology court systems in India. One of the most significant projects was the e-courts project that was launched in India in 2005, even before the 2019 and the 2021 example that I gave you a couple of minutes ago. And the Supreme Court of India adopted this e-courts policy through the National Policy and Action Plan for Implementation of Information and Communication Technology in the Indian judiciary. The idea was that the e-court initiatives, introduced technology in the courtroom. So this was one of the first interactions when the judges were told to be court friendly, judges were told to be technology friendly in courts. And what I've been told, and the way what I have been told in many forums, lawyers and judges are more always averse to technology because we all like reading in paper. So we hate technology. And the most obvious and observable feature of the system of this e-courts when it was introduced was the deployment of the technology within the court itself. So the judges now in India were provided with LCD screens, touch screens, or projectors that were connected, say, via a local network to disseminate information to the lawyers. Electronic boards were displayed to queue the number of cases. So all of this, was one of the initial stages in which the way the e-system was introduced in India. But if you look at the data on the judges and whatever the findings I could find in terms of research, in order to better understand the impact of these specific judges, usage of AI is, in terms of judicial making, is more helpful. Once their identity, the training, the experience, all of it is there available in the database. And we try to construct somewhat a database of judges for the courts of India. So the idea is that you extract data from the judges' handbooks, which has been released by the Supreme Court of India, or the information from various high courts website. And the data that you come across is that approximately 93.5% of the judges are males and 6.5% are females. And their collective experience somewhat covers approximately 70 years of the experience of the ever since independence. The legal data which is released by all of these judges, or for that matter, the Indian judiciary, is voluminous, it's messy, it's complex. So cleaning and the pre-processing of the data is critical for any form of analysis that you would want to do, especially, so for supervised algorithms, trained on this data. So the traditional empirical legal studies have typically addressed this issue by relying on a small scale of data sets, where legal variables are somewhat manually coded. And when you go on to examine this data in terms of the scope of the Indian judiciary, it's quite huge, it's voluminous. So it's one of the biggest challenging is pre-processing the data and the availability and the variability of the reporting across states and districts. So that becomes quite a challenge. In terms of if I talk about the identification of the laws and the acts, the legal texts do not currently employ any standardized citation for referring to acts or laws. So for example, if I have to quote the Hindu Marriage Act, it may be referred to in a variety of ways. So some people would try to search as under Section 3, Clause 2 of the Hindu Marriage Act, or some people would try to search as under Section 13, Clause B of the Hindu Marriage Act, or rather than writing the term Clause B, they would put the Clause B in bracket. So again, machine learning tools can also be used to address this issue. So the idea is that, when you're working on a topic like this, the idea is that you have to use a set of tools that create some sort of a mathematical representation of the text in the form of, you can say, vectors. So the term frequency or the inverse document frequency is one such popular method which you can use to represent a string of words, which can act as a vector of scores that reflect how frequently a word is used within a text and how infrequently it appears in the corpus. So the identification of specific laws and acts, it opens up new opportunities for legal analysis. And we can, for example, compare, the types of cases that come across India, and it takes how much time it takes to process them. So this is critical in being able to understand where the biggest delays in system come from and how they may be resolved. There is obviously, just like the comparison that I gave you from the United States and how AI is also somehow disadvantageous at times, there are also concerns in India when it comes to stereotyping and discrimination in the courts. And typically, it cite a single case or say a small set of cases to highlight the issue. Bias is shown by the courts or even a single judge is difficult to identify and is to be analyzed rigorously. But this challenge is, of course, not unique to judiciaries. This exists across bureaucracy as well. It is something which is not very peculiar to one profession. So the idea, to conclude my talk is that, the idea is that, any sort of building such algorithms, it requires a feature-rich data set, typically consisting of variables that include the litigant characteristics, you can say the caste, the gender, the location, the type of the crime committed, the lawyer characteristics, the court characteristics, the case details, where you are required to fill the details, the evidence required, or say the additional characteristics like date, year, date of birth, and even for that matter, case outcomes, such as your granting of bail or dismissal of a case. So, and the idea is that an algorithm builder would write a learning procedure that would aim to provide a somewhat a predicted outcome from a broad range of inputs, choosing from a variety of models with support vector machines or decision trees or the Bayesian networks and neural networks. The architecture of all these models, feature multiple sequential layers of intermediate variables that eventually go on to connect the input features, or you can say the output classes. So all of these models stand a sharp contrast to the traditional statistical methods, such as the linear regression we use. So the idea is that all of this is at quite a nascent stage, and there's a need to identify the loopholes in a lot of way to identify the causal effect of the legal rulings, randomizing cases to judges, has been predicted to be quite harsh or lenient, it generates some sort of an inference on the long run causal impacts on the length of the sentences also being given by the judges. So there are various issues to that, but overall, the system needs to be better understood, and the Indian judiciary is on the way to it, but it's quite new. But the better the data sets are built and the better the keywords are used, I feel that it could be used to address a lot of problem, and a new relationship between the human and machine can be effectively utilized in judiciary by using various economic tools, like even the randomized controlled trials, for which Professor Diplo won the award. So I think this is it from my end.
Perfect. Well, thank you so much, Nidhi, because I'm just aware of the time, and I was thinking that, first of all, I think my takeaway is all the positives that you have outlined and how we can approach this. You talked about the reduction in the backlog, the less workload for the judges. But I think one that I quite like is that sort of almost a positive externality being the fact that, there's actually, it's moving towards the digitalization of the judiciary. Whilst we don't have time, and but I will still ask you one question, which you have about a minute to answer, because that brings us to this. And you also talked about, of course, the issue of the magnification of biases. And I'm assuming that that's something, whilst it happens everywhere, probably also is a concern in India too. The question is, to what extent are the judges, trained, understanding, and educated about all of this? So they've been sort of asked by the Supreme Court, use these apps, go this way. Is there also a program which is in place to basically, in a way, make them also feel comfortable to complement their work with AI? You have 1 minute only to answer, and then we gotta go. But I just thought I'll ask you whilst we have you here.
So definitely there are training programs which is conducted even for the beneficiaries across government sectors in India, not only in judges. So it goes without saying that the judges also being the holders or the providers of justice in any democracy, the training is imparted to them through various government functionaries. And the Supreme Court of India itself, it conducts a lot of legal training programs in terms of training in the technological aspects of usage of these softwares. So judges do get the training. There's no doubt about that. And it's provided by the technical experts in India.
Perfect. Well, thank you so much. This was really fascinating. Thank you, Nidhi, for this overview. I believe we're going to pass directly to our next session. I just want to make sure that Tatiana is in the room. Tatiana, if you're there, just give us a shout. We're just waiting for you. I think I see you.
I am here. I was trying to tap the correct button to unmute.
All right, super. You can switch on your camera as well, and I quickly introduce you. Hey,
I think.
Hello. So I'll just start now. I now welcome you all to the session with Tatiana Juhl from Danish Business Authority. Tatiana manages the Danish Business Authority's one-stop shop for new business models, which is a single point of entry that helps businesses ease their way through the regulatory landscape and bring their ideas to market quickly. Tatiana will share best practice with us from Denmark about an extremely interesting and relevant topic, which is regulatory sandboxes. And as a reminder, regulatory sandboxes allow businesses to safely test and also interact with regulators. Businesses can test their products and make sure that they are compliant. It is a place for trial and error, but is also a great way, in my opinion, to break the barrier between the regulator and the economic sector. So the title of Tatiana's talk is How Regulatory Sandboxes Can Promote Innovation and Create Better Regulation. Now this session will last, I suppose now around 40 minutes. But of course, your views are very important for us. We wish for the discussions to be interactive. So please do participate in the Q&A. Please do put your questions in the chat. And with that, I'm going to pass the floor to Tatiana, who I believe has also a presentation for us. Tatiana, the floor is yours.
Thank you so much, and thank you for inviting me to participate today. As you said, I work with the Danish Business Authority. We're part of the Danish Ministry of Industry, Business and Financial Affairs. And I work in an office which overall aims at promoting green and responsible business development. And as you said, my focus area is innovation-friendly regulation. In our day-to-day work here at the office, we can see that many startups and innovative companies often encounter rules which are either unclear or outdated when they are developing new technologies, which can benefit society and the green transition, but they're hampered in their way to the market. As part of my work with innovation-friendly regulation, I'm currently heading a working group in the relatively newly established Agile Nations Network. And here we're currently making a case catalog on regulatory sandboxes. And I would like to introduce you both to the Agile Nations Network and the case catalog. But first, a few more words about the topic of my presentation, which is how can regulatory sandboxes promote innovation and create better regulation? Let me just start off by saying I do not have the final answer to this question, but I hope to give you some insights into current cases and also especially to inspire further seeking of and sharing of knowledge in this field. So I'm aware that the topic of this conference is artificial intelligence, but I'm also going to speak more broadly about tools for regulating emerging technologies with this special focus on the sandboxes. So as many of you are probably already aware, the sandboxes were a concept was initially developed in the financial services sectors, where regulators found that emergence of new fintech solutions to some extent challenged current regulation. With the regulatory sandbox, a space was created where regulators and policymakers could investigate new technologies in dialogue with startups and innovative businesses. So the purpose was to create a safe space that allowed for test and development of innovative fintech solutions, while at the same time upholding necessary protections for consumers and society. And based on lessons learned, regulators could allow for innovations and at the same time evaluate whether current regulation was still fit for purpose, or, for example, if they needed to issue new guidance. An example of this is the Danish FinTech Sandbox, which has enabled testing of new machine learning models for assessing house sales prices. In the sandbox, the Danish Financial Conduct Authority explored how the model and its output could be described and documented. There was also an issue with current regulation, which stipulated that a physical inspection must take place when assessing these housing sales prices. And following testing, the Danish Financial Conduct Authority was able to issue new guidance to the sector as a whole on how machine learning could be used in this field. And so these years, we see that the concept of regulatory sandboxes has spread to other sectors, where it is used by regulators and policymakers to gain insights into the potentials and the challenges of emerging technologies. If we could go to slide 2. I'm not sure who's managing that. Am I managing the slide myself? No, I'm not. Okay. So I just brought you some quotes from the OECD, the World Economic Forum, and the European Union, because regulatory sandboxes is definitely a subject of interest for all these organizations. The OECD specifically recommends that governments enable greater experimentation with a view to the fact that these innovations can help solve some of the larger society issues we're facing as societies. The World Economic Forum has also noted how unclear regulation can hamper innovation, and recently the European Union, the Council of the European Union, issued a conclusion on regulatory sandboxes to encourage use of these and also knowledge sharing in the field. And which is also a key point from the OECD and the World Economic Forum to share knowledge. And it was also to this end that the Agile Nation Network was formed. If we can jump to the next slide. It was formed in 2002 by a group of countries and with assistance from the World Economic Forum. And the purpose of this network is to enable testing of new technologies, also cross borders. It's an open network. We invite interested countries to take part. And it's also in this network that I'm heading this work with creating a catalog on regulatory sandboxes. If we jump to the next slide. So we in the Agile Nations conducted a survey that was actually similar to a survey conducted by the Slovenian presidency in the European Union, which asked some overall questions. Does your institution have any examples of regulatory sandboxes? Do you have any examples of other tools that might not fit this definition, but is similar? And can you perhaps share evaluations and key lessons learned? And so we collected a lot of data on how these sandboxes are actually organized, when they were established, what's the legal basis, what's the eligibility criteria to participate, and so on, as well as looking at the impacts on lawmaking process. Then we can jump to the next slide. So we managed to collect 69 cases from a total of 23 countries. As you can see, the survey answers show that these sandboxes are being used across a wide array of sectors. Financial services and mobility are definitely the sectors where most countries are either using or planning to use sandboxes, followed by energy, ICT, and data. And then we have quite a few horizontal crosscuts, like involving all sector sandboxes. And then we also have some examples from the health area. Financial services obviously includes fintech, insurance, banking. Mobility includes drones, shipping, self-driving vehicles and units, as well as autonomous shipping. ICT and data includes artificial intelligence, use of data, smart cities, and energy has a particular focus on renewable energy sources. And we also have one example on nuclear plants. So let's jump to the next slide. So there are no, there's not a absolutely universally agreed upon definition of sandboxes, but they do have similar traits. First and foremost, it's a space where regulators can temporarily derogate from existing regulation, provided that experimentation takes place in a safe manner. Experimentation can take place on paper or with data sets, and it can also take place in real life, either in physical test zones or in public areas. And then last but not least, guidance from regulators is really key. And it's worth noting that not all sandboxes can derogate from law, but all sandboxes provide guidance. And some regulators also note that guidance in many cases is actually sufficient. Sometimes you do not need to derogate from law or to change the law at hand. Let's see. Well, let's jump to the next slide. So I brought some examples from each sector on how the purpose of the sandboxes and how it affected regulations in the cases where it did. Because the sandboxes often say that they would like for the sandbox to inform regulation, but given the fact that many sandboxes are still relatively new, we're yet to see the full effect on regulation and innovation. But I brought examples where something actually has happened. In the United Kingdom, the regulatory sandbox for fintech was established back in 2016. And the Financial Conduct Authority has said that these sandbox testing insights played a key role in the development of the FCA's policy work on crypto assets, open banking, and other areas. It allowed the FCA to see how new technologies and innovations work in the market, what works for consumers and what doesn't, what risks arise from new technologies, and what controls can be put into place to mitigate those risks. So that's the financial services sector. I'm just going to run through each example, and I guess we're taking questions, dialogue at the end, Aisha?
Yes, but you have time. So I think, it's good that you present with your own, because we don't have many right now. So I'd rather you actually share properly what you're saying.
I'll just keep speaking. Next slide, please. In the mobility sector, I have an example from Canada where a regulatory sandbox for remotely piloted aircraft systems, or drones in short, was established in 2019 to allow for operations beyond visual line of sight. That means you can't, obviously you can't see the drone when it's so far away you can't see it. And Transport Canada stated that the informations and lessons learned from the issuance of these certificates to conduct these drone flights has created the foundation for Transport Canada's upcoming regulatory framework for lower risk beyond visual line of sight operations. So here you have an example of a regulator very actively going out and using the sandbox to seek information on creating a whole new regulatory framework. Next slide, please. In the energy sector, I brought an example from Denmark. In 2019, we established a regulatory sandbox for energy technologies. The purpose was to enable innovative energy technologies, energy supply and storage solutions. And today, the Danish Energy Agency has found that through the sandbox, they have improved their understanding about specific provisions in the Danish energy regulation that the sector perceives as an impediment or challenge to the development of the sector. So I think a point here is also that in a way, the sandbox here can also be seen as a mean of, usually when you have a new law, you send it out into a formal hearing. This is like a pre-hearing. This is where it's a tool for gathering and informing information before you issue new law. So the Danish Energy Agency has said that they at some point will create new law, and they believe that the sandbox will help inform them for the draft for this. Next slide, please. So in Singapore, they made a regulatory sandbox for telemedicine and mobile medicine in 2018. Also to create a safe environment where they could test these new models. Following testing, Singapore has listed direct telemedicine service providers who have demonstrated that they are aware of the risks and benefits of telemedicine and that they are following practice guidelines set out by the ministry. So here you actually have an effect on providers who are able to enter the market following the sandbox. And finally, I have another example from the UK. That's the next slide, please. The United Kingdom has a data protection regulatory sandbox, which aimed at supporting companies who are creating products and services which utilize personal data in innovative and safe ways. And here there's actually no flexibility and no possibility to derogate from law. The purpose of the sandbox is to support privacy by design and to help organizations figure out how they can develop their services and at the same time process personal data in a safe and ethical manner. So those were my 5 examples. Those are the good examples. A lot of the sandboxes that we heard from are still looking at what the projects will mean for regulation. Yes. What do I have on the next slide? Yeah, that's it. To conclude, I would like to say that the whole purpose of this endeavor is not to make a document that's set in stone. We see it as a living document, and we also see it as an open invitation to anyone who's interested in contributing to our work. The next step for the case catalog will be a quality text check over the next month or so with all the government agencies who are mentioned in the case catalog. It's around 200 pages long, and we're looking forward to sharing it at a later point in time.
Perfect. Well, thank you so much. We have one question, in fact, from Elliot, and I was even wondering if Elliot, you could come out and say it. You might want to do it live. But before we go there, I had one as well, Tatiana, because it's just trying to, it's wonderful to see that, and I know that it's also relevant for us. And if I'm now thinking from a Swiss perspective, the question is, and very practically, you have these. You talked about the agile network that it exists. Is it only governments that are becoming part of that, or can individual companies also become part? That's the first part of the question.
Yes, it's actually aimed at government because it's aimed at supporting knowledge sharing between government agencies on how they can work with innovation-friendly regulation. But with the activities we are inviting in companies. So, for example, in my working group, once we finish the catalog, we would like to do webinars on innovation-friendly regulation in certain sectors. And there we would like to invite companies to share their experiences with sandboxes or share their perspective on what is needed for innovation-friendly regulation. So in that sense, it is open to a wider set of
it is open. But then for those that are still thinking, so I know, for example, in Canton of Zurich, we're thinking about this approach overall in terms of sandboxes, and regulatory sandboxes could be maybe a subset of that. So what would be like the steps? Is there? Do we just reach out? Do we reach out to you and we try to sort of have a bilateral kind of discussions and then go there? And what is the concrete way to go about it? And that is, of course, relevant not just for Switzerland, but all of the other countries and companies that are listening to us from the other parts of the world as well.
We're trying to have a very informal approach, so coffee meetings, webinars, and we in Denmark also learn from helping connect other people and listening in on their discussions. And in Denmark, we're also trying to inspire other Danish ministries who do not currently have sandboxes to look at this as a possible tool. And we have dedicated some resources to being sort of a contact point. So we'd be happy to pick up if you reach out.
Perfect. Question from Elliot. Elliot, you want to ask it yourself, perhaps? You've got two?
I think he wrote that he needed the administrator.
Oh,
he doesn't have the right.
You cannot unmute. All right, let me just go to you. I think I can unmute you as well. Does that work?
Yes, it works. Thanks, Aisha.
Right.
And thank you, Tatiana, for the interesting presentation. This might be a bit, I hope it's not too much of a digression to ask whether you've learned that regulators should informally correct problems by talking with the companies and learning from them and trying to correct issues by talking with them versus a more formal enforcement approach where there are financial or other penalties. And do sandboxes tell us about one or the other approach? And are there some conditions or sectors where you might need the former versus the latter?
Well, thank you for the question. Good question. I don't see it as an either or. I think something I forgot to mention was that a very important part of sandboxes is also to communicate results to the wider sector, because it's important with the sandbox not to give preferential treatment to one company aside from others. So right. it shouldn't be informal in that sense. All results should be communicated, and it's always a criteria as a company. You have to say, I'm okay with that. Of course, business secrets won't be shared, but everything that can be communicated will. So I really think it should be seen as a supplement to how you work as a government agency. And I also think you should be aware that for many companies working with emerging technologies, they're not necessarily organized in business organizations, so they're not able to communicate their needs as clearly and as timely as those established companies, which are part of a business organization, which are aware, oh, now we have a hearing coming up on this new European law, this new national law. So in a way, I think you're also a little obliged as a government agency to open this avenue as a way of paying attention to what is going on in the business community.
Okay.
Thank you.
And another question, Elliot, or I move to one in the chat?
Yeah, a quick follow-up, which maybe this is, I think your answer will probably be the same, is do you see separate roles for judges versus regulators, that kind of related to our session earlier, in terms of, they say that judges can often make decisions more on a case by case, and regulators need to promulgate more general rules to make things more flexible. Or can judges help with that? And kind of the same question, like, are there some cases where you need regulators versus judges making decisions?
Well, I think also there's also an important distinction between guidance and counseling. And as a government agency, you can actually only provide guidance unless you provide, it's clear that now you're getting a decision from a government agency. Usually you have to pay for that, some fee, and then you have a decision and that holds. But otherwise, it is actually guidance that's taking place in the sandboxes. So I think that's different from being a judge and making a decision. But I'm not sure you feel
that makes good sense. Thank you.
Okay. Yeah.
So there's one more question here with regards to the EU AI Act, Tatjana. As you know,
Yes.
that there is this other aspect. So one aspect is, of course, some of the constraints that are coming through, but the other is also to try to empower the innovation. And one part of it is sandboxes, right? And the question really is, and my understanding is, even within the discussions now, there is more discussions on how these should be treated and what should be happening with them and should be brought in. I mean, maybe for the audience, if you could just tell us a little bit what's happening in that particular area under the context of the EU AI Act.
I am aware that negotiations are taking place, but I'm not a direct part of it.
Okay.
So I'm afraid I'm not able to share much on that. But I'm aware that there are discussions about regulatory sandboxes in that regard also, which I see as a positive.
Yes.
Because we are coming with quite strict regulation. We should also make government agency comfortable with exploring the opportunities in AI.
Perfect. And then we have another, it's more like a comment, also saying that you should also consider some examples from Latin America. Do you have actually countries from Latin America that you're working with? Are they reaching out? Is there a way for them to do that?
I would love to have examples from that part of the world. We've only looked at, I looked at the European survey, and then we have the members of the Agile Nations. But it's now we have the format for the case catalog. So I would love to add some examples from the rest of the world.
Okay, so what I can say is, if we have interested parties, they can sort of come to us, and we can try to see if we can raise it over to you in that case.
Oh yes, so, definitely. Yes.
Perfect. Well, that's a little bit all we have right now. Anybody else with any questions here? No, not really. There is just some information. Well, so I think with that, I would say thank you so much. Wonderful to have had you. I am hoping to, of course, continue the dialogue also out of the forum with you. I think you're doing incredible work, and it's wonderful to have this contact. And I think that sort of goes to what this whole platform is all about, is to make those bridges between, the different countries and the different great work that has been happening. So thank you, Tatjana, for being part of our discussion, to being part of our expert groups here with RegHorizon and ETH Center for Law and Economics. And with that, I think it's been a long day, but an extremely exciting day. So I'm going to allow now my colleague, Professor Elliot Ash, I'll pass it over to you, Elliot, to sort of give us a little bit of your reflection for the day, and maybe to close the session for us. So thank you from me, and over to you, Elliot.
Thank you, Aisha, and thank you everybody for joining. It's now time to conclude day 2 of the 2022 AI Policy Summit. I hope you agree that this has been an enlightening collection of sessions, and many thanks to all the panelists and others who contributed today. For me in particular, it was amazing to hear how judges think about AI in their own words. And, I've studied judges and AI in my work using data sets, but it gives a much more personal spin on it to hear from the judges themselves. That was really informative for my future research. But, leaving research aside for a second and taking the perspective of a global citizen in this age of artificial intelligence, I was impressed by the judiciousness with which the judges discuss these issues. For me, that was an encouraging counterweight to the hype that one often hears from companies or politicians or tech rags. In a similar mode, the presentation by Marcus on NLP and climate change gave me some optimism that the climate challenges induced by industrial technologies might be addressed by AI solution induced by post-industrial technologies. Overall, we've heard from diverse voices across the world and across different segments of society. And that is the value of this summit, making connections among judges and data scientists and regulators and social scientists, not to mention the public. Now, to conclude, the online part of the summit continues tomorrow and at the same time and the same place. Tomorrow's theme on AI and democracy follows nicely from today's theme on AI and justice. You should please look at the program on the website. We'll put the link in the chat to see the full agenda. But to name just a couple of sessions that I'm excited about is we'll hear from a member of the Swiss National Parliament and a member of the European Parliament on the upcoming AI Act. So I'll be there, we'll be there. I hope to see you there as well. Thank you and good night.
Thank you all.